Senate Committee Room, A305. Did you know that you can watch the Senate live on YouTube? Visit the channel by browsing to youtube.com/@Senate of Virginia. That's youtube.com/@Senate of Virginia. Senate Committee Room, A305. This is the Senate of Virginia, Richmond, Virginia. This is the Senate of Virginia, Richmond, Virginia. Senate Committee Room, A305. Did you know that you can watch the Senate live on YouTube? Visit the channel by browsing to youtube.com/@Senate of Virginia. That's youtube.com/@Senate of Virginia. Senate Committee Room, A305. This is the Senate of Virginia, Richmond, Virginia. This is the Senate of Virginia, Richmond, Virginia. Senate Committee Room, A305. Did you know that you can watch the Senate live on YouTube? Visit the channel by browsing to youtube.com/@Senate of Virginia. That's youtube.com/@Senate of Virginia.
Senate Courts of Justice Committee meeting to order. Clerk will call the roll. What's happening?
Mr. Chair, you have a quorum?
Thank you, MJ. No, not yet. That's the way we like it. So, ladies and gentlemen, we have 52 bills in the docket and 3.5 hours. The way we're going to handle this is we got a couple bills to go by for the day. We have some identical uncontested, and we're going to hit the identical that have to go to finance. We're going to try to do those two in a block. Then we have identical bills that are contested. We have to vote those separately. Then we have identical that need to go to finance that are contested. Do those separately. Then we're going to do bills that are similar. We got to work through those. Some are going to be conformed, some are not. Then we have another block of similars and some more similars. And then at the very end, we have a regular docket of bills we've never heard before. I think there's about 12 or 15 of those. Those will come last. So in other words, the sign-up is not going to necessarily govern how we handle calling the docket today. I will cover it, I guess, depending on I'll use the sign-up in reference to each block. But we have to be very efficient to get through these today. We have a finance deadline we're working off today. Then they've asked us to get most of these out of here today. So that's why the docket is structured as it is and why we have so many on the docket. Aside from the fact that the House sent us more bills than we passed out of this committee ourselves. So, first of all, House Bill 2061 by Delegate Garrett needs to be re-referred to the Committee on Agriculture, Conservation, and Natural Resources. Senator Deeds moves, Boyd seconds. Clerk will open the roll.
Is that the Buckingham County thing? Cumberland
Yeah,
County?
I think so, yeah.
All the property disputes used to be here.
Yep.
Under that.
Great, bill reports. House Bill 1864, Delegate Hernandez, he's asked that bill go by for the day, and the bill will go by for the day. For the committee members' information, House Bill 1733 by Cole was going to be referred to rehab, but Senator Boysko's asked us to consider it here, so we'll take that up in a little while. So next up, we have a block of identical uncontested bills. First of all, we have House Bill 1845 by Delegate Arnold, limitation on prosecution of felony to lapse of time for probable cause. That's identical to Senate Bill 804 by McDougal. Then we have House Bill 2174 by Clark. This has to do with legal malpractice for estate planning. It's identical to Senate Bill 1115 by Sturdivant. We have House Bill 2370 by Wilt, having to do with cigarette delivery sales, which is identical to 1067 by Peake. Deeds moves, Boyce seconds, that we report those bills to the floor in a block. Clerk will open the roll.
Ayes 11, no zero.
Thank you. Those report.
Mr. Chairman?
Yeah.
HB 1733, although it was heard in rehab.
Yeah, I just mentioned that. I'm sorry.
It's identical to SB 7.
Yeah, Boyce just
1372.
pointed out that I had said used her name instead of your name. We'll take that up in a minute because it was not heard in this committee, so we need to talk about the substance briefly. But so then on the identicals, need to go to finance. I have House Bill 1968 by Delaney. This has to do with crime victim compensation. It's identical to Senate Bill 1200 by Deeds. And then I have 2406 by Delegate Scott, which has to do with escape from jail or custody, which is identical to Senate Bill 861 by Reeves. Those bills, so Deeds moves, Boyce seconds, that those bills be reported and re-referred to finance. Clerk will open the roll.
Ayes 11, no zero.
Okay, then, why don't we take up coal before I forget, Senator Favola? You ready to do that? Sure. Okay, so this House Bill 1733 by Delegate Cole is a bill that was heard in the Rehab Committee, and is it identical to yours?
Mr. Chairman, it's identical to Senator Suderline's bill, which was Senate Bill 1372, and that passed the Senate 39-0. What this bill does is it sets up a process for courts to determine sort of a clear and convincing evidence when they're making a determination on the relief of child custody. But that determination, of course, will be based on a study which we directed the ombudsman, the children's ombudsman, to convene.
Right, and this has to do when a parent's giving up custody of their child.
That is correct.
Right. Again, this bill was heard fully in rehab, reported unanimously, reported out of the Senate unanimously.
Correct.
So Senator Favola moves, Deeds will second. They report that bill to the Sabrina, MJ, somebody. Does this have to go to the finance or the floor?
No, it does
Okay.
not.
And the motion is to report it to the floor. Clerk will open the roll. So good.
Ayes 11, no zero.
Great. All right, one page down, 7 to go. All right, next up, we have the block of identical bills that were contested votes. First up, we have House Bill 1960 by Delegate Bennett Parker. This is identical to Senate Bill 744 by Favola. This has to do with firearm transfers to another from a prohibited person. I think when there's a protective order in place, I think was the bill. This reported out of the courts 8-5, reported out of the Senate on a party line vote. Clerk will open the roll.
Report.
I'm sorry. Deeds moves, Boyce seconds to report the bill.
Ayes 9, noes 3.
Thank you, MJ. The next, we have House Bill 2746 by Tran. It's identical to Senate Bill 765 by Favola. Has to do with incapacitated persons. Is this the one about voting?
Yes. Remember, it was about the
Right.
conservatorship and guardianship, and
Right.
the default now would be the
Right.
person retains the right to vote.
Right, we heard this fully in committee. It came out of this committee 10-2 to 3. It passed the Senate 39-0 with one abstention. And came out of the House kind of mixed up too. So Deeds moves, Boysko seconds to report the bill. Clerk will open the roll.
Ayes 13, no zero.
Great. Next block, we have block number 5. These are identical bills that need to go to finance that were contested votes. First one is House Bill 1715 by Delegate Watts. It is identical to Senate Bill 939 by Salim. Has to do with mail theft.
Second.
It came out of here 13-1, and it came out of the full body 39-0 with one abstention. Deeds moves, Boysko seconds to report and refer to finance. Clerk will open the roll.
Slip of the
Say what?
Ayes 12, noes 1.
Okay, bill reports and refers to finance. House Bill 1977 by Hernandez. This is the hospital gun bill that we've heard a couple different years in a row now. The latest version of it. Yeah, it came out of here 8-6-1, on the floor 20-18. Deeds moves, Boysko seconds. The bill be reported, be referred to finance. Clerk will open the roll.
Ayes 9, noes 4.
Next up, we have 2631 by Hayes. This is identical to Senate Bill 891 by Salim. This has to do with a 5-day waiting period on guns. 20-18 out of the full body, 9-6 out of here. Deeds moves, Boysko seconds. The bill be reported, be referred to finance. Clerk will open the roll.
Ayes 11, noes 2.
You can just tell him to change it.
Change Pete.
All right.
Ayes 9, noes 4.
Thanks,
He's
MJ.
running against Open Shane. He's
Yeah.
planning on running the
Yeah,
candidate.
no, he wants a primary for Open Shane. Okay, so next up we have block 6. This is a big block of stuff, and this has to do with conforming, and this is where it gets complicated. So, I'm going to call this up in the order on my sheet. First up, I have Delegate Thomas, who has 1627, which is kind of related to House Bill 1630 by Keys Gamara. Both bills deal with the same subject matter of e-discovery, and we can only pass one. It's my understanding that Thomas and Keys Gamara have agreed that the e-discovery stuff is going to be taken out of Thomas's bill. Is that correct, Delegate Keys Gamara? Okay, so.
Conform to 1193.
Okay, so we're going to conform 1627 to 1193. Is that right, Sabrina? Sabrina, is that right? We're going to conform. Okay, so we're conforming 1627 to Senate Bill 1193. Deeds moves, Boysko seconds. All those in favor say aye.
I
Aye.
move to report.
Okay, and then Deeds moves and Boysko seconds that the bill be reported referred to finance. It came out of the Senate 15-0, I'm sorry, this committee 15-0 and the Senate 40-0 as conformed. Clerk will open the roll.
Ayes 14, no 0.
All right, and then next up I have 1630, which is Keys Gamara, which now I think only has to do with electronic discovery. It is.
Conform to 963.
It's similar to Senate Bill 963. It's my understanding the patrons have confirmed and that they're going to conform to Carol Foy's bill. So Deeds moves, Boysko seconds that we conform to 963. All those in favor say aye. Aye. Anybody opposed? No.
And re-refer to
Deeds moves, Boysko seconds. The bill be reported as conformed and re-referred to finance. Clerk will open the roll. It was 9-3 to 2 and 33 to 6 on the 33
Ayes
to 6
12,
on the
noes
floor.
1.
All right. Next up, we have trigger activators by Jones, 1660. It's my understanding that the patrons have agreed they're going to conform this to Senate Bill 886 by Perry. Came out of here 9-6, the floor 21-18. So Deeds moves, Boysko seconds to conform it to 886. All those in favor say aye. Aye. Anybody opposed? No. Deeds moves and Boyce goes seconds that the bill is conformed, be reported and re-referred to finance. Clerk will open the roll. Salim.
Ayes 8, noes 5.
Somebody got Salim.
His proxy's gone.
All right. And next up, we have House Bill 1726 by Price, which is trespass with an unmanned aircraft system. It is similar to Senate Bill 757 by Locke. It has an enactment clause on it, which we don't do, telling the Crime Commission to do something. I saw Price here. She's still here? There she is. We don't need to conform, the language is the same otherwise, but for the enactment clause, right? Okay, so Deeds moves and Boyce goes seconds to strike the enactment clause. Oh, there's a sub? That does that? That does what I
I move
said?
we conform the
Okay.
bill to 757.
Okay. Deeds moves and Boyce goes seconds, that we just conform the bill to the bill we passed. All those in favor say aye. Aye.
I
All
move
opposed,
we
no?
report and re-refer to finance.
Okay, Deeds moves and Boyce goes seconds to report the bill and re-refer it to finance, and that the chair write a letter to the Crime Commission asking them to look at the things reflected in the enactment clause. Huh? No, MJ, why does it say Marcia S. instead of Price? Should say Price.
Marcia S. Price.
Okay, all right. Anyway, the clerk will open the roll while we work on the computer.
Ayes 14, no 0.
All right. Slim, you need to undo your proxy over there. Next up, I got Campbell, which is similar to House Bill 1815. Campbell, similar to Senate Bill 1142 by Owen Shane.
I move we conform it to 1142.
My understanding, the patrons have agreed to that, I think.
It's just an amendment.
Oh, it's an amendment? I'm sorry, we're not conforming.
It's
A technical amendment conforms.
Okay. Say Deeds moves, Boyce goes seconds to conform. All those in favor say aye. Aye. Anybody opposed?
Report and
No.
refer to finance.
Okay, Deeds moves, Boyce goes seconds, report refer to finance. Clerk will open the roll.
Ayes 14, no 0.
Okay, bill reports and goes to finance. I'm not seeing any patrons get up and leaving. I feel like we're not making any progress here. Okay. House Bill 1869, McClure. This has to do with the boyfriend loophole. It is similar to Senate Bill 883 by Perry. We're conforming it to Perry, and you all are continuing the conversation. Is that right? Huh? No, we're not. No, you're good. We're conforming. You guys are continuing the conversation, right? Okay. Hopefully, avoiding conference.
Move.
So, Deeds moves, Boyce goes seconds to conform to 883. All those in favor say aye. Aye. Anybody opposed? No. Okay. Deeds moves, Boyce goes seconds. The bill be reported and re-referred to finance for them to continue their conversation. Clerk will open the roll.
1876.
I did? No, it's next.
Ayes 9, noes 5.
Okay. All right, bill reports and goes to finance. Next up, I have 1876 by Carlson, having to do with higher education, guns on college campuses. Conforming?
Yeah.
Deeds moves and Boyce, it's similar to Senate Bill 1182 by Deeds. Deeds moves, Boyce goes seconds, we conform it to Deeds. All those in favor say aye. 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 Anybody opposed?
Report
No.
and refer.
Second.
Okay, Deeds moves, Boyce goes seconds, we report and refer to finance. Clerk will open the roll.
Ayes 9, no 6.
96, bill reports, goes to finance. Next up, 2124 by Maldonado. This has to do with what some people call synthetic media, what other people call is AI stuff. It is similar to Senate Bill 1053 by Eben, which we added an enactment clause and referred it to Boyd Graves for them to come back for an answer for the second year in a row.
I move we conform it to 1053.
Deeds moves.
It's not going to find it.
Carol Foy seconds that we conform it. All those in favor say aye. Aye. Anybody opposed? No.
Report.
Deeds moves and Boyce seconds. We report and refer the bill to,
Don't have to.
This doesn't have to be.
okay, report the bill, even though it's in my finance blog. Okay. Report the bill. Clerk, open the roll.
Just conform. We just made it up.
Oh, we nuked it. Okay, I got it. All right.
Ayes 15, no zero.
All right. Next one's kind of a big one, but doesn't seem like there's any discussion on it. This is House Bill 2723 by Herring. This has to do with the sealing, criminal records, conviction sealing bill, the Crime Commission bill. The bill is similar to Senate Bill 1466 by me, and Paige and I have talked. The intention is to put this in conference in case there's any more things that crawl out of it. So Deeds moves and Boyce seconds. The bill be conformed to my bill. All those in favor say aye. Aye. Anybody opposed? No. McDougall has a question.
Mr. Chairman, I know that we've been adding a lot of things
Yeah.
in this, because I think there are 3,000 statutes, and instead of saying we want to seal these, we said we're sealing them all, and now we're trying to claw back all the things that shouldn't be sealed. Which, one of the questions I have is financial exploitation of people that are older. Is that in the bill currently?
No.
Okay.
There's no financial crimes in the bill. There's no financial crimes on the exclusion list.
Okay.
I think Kristen Howard's here somewhere. She'd nod her head.
So, Mr. Chairman,
Where's Kristen Howard? Is she in here yet? There she is. That's right. I'm saying that right? Yeah, okay.
so, Mr. Chairman.
Yeah.
So if somebody steals from somebody's grandmother or parent, then that would be sealed and nobody else would be able to find that information out.
Sort of.
Isn't that right?
Sort of. It would be eligible for somebody to petition to have it sealed, and if a judge, after 7 years on a misdemeanor, 10 years of good behavior on a felony, and they would have to convince the judge that they've been good and that they would suffer no manifest injustice, or they would suffer manifest injustice by continuing to be on their record, et cetera. Right?
Yes, Mr. Chair.
It's just eligible for sealing. It's not required.
So we're talking about 18.1178.1, financial exploitation of a vulnerable adult. Is that
Yeah.
the correct statute? That is not in the eligible offenses.
It's not in the exclusion list.
It's not in the exclusion list, which means it's not eligible.
No, it is eligible. It's eligible for sealing.
Correct. Yes,
Not required to be sealed. It's eligible to be sealed.
that is correct.
He's trying to confuse the witness.
Yeah. Any other questions?
We'll talk about it later.
Okay, apparently we're going to talk about it on the floor. In front of the big cameras. Okay, any other questions about the bill?
Mr. Chairman. One more while Kristen's here, just
Yeah.
to make sure I got this right. So embezzlement also, so if somebody
Correct.
embezzles from your business, then that would be eligible to be sealed and any other employer wouldn't be able to know about that.
No. No, it's eligible to
that
be.
right?
No, it's eligible to be sealed, but if there are certain employers that are allowed to look behind sealing, and I believe employers where there's money handled, I think might be one of the eligible. No, you're making faces.
We
can
have a
look at that on
list
the
of
floor.
about 25 reasons that are permitted to look at sealed records, so I can provide that to you if you'd like.
Mr. Chairman, so,
Yeah,
but
Senator McDougall.
bottom line, if you're a small business hiring somebody that might have access to all your finances, even though they might not be in charge of them, you would not be able to know that somebody embezzled from somebody else.
Senator, what I would say is
Yes, isn't that right?
no, it's not entirely right.
Just
The-
partially right?
Well, it depends on what kind of employer they are and whether they are the kind of employer that's allowed to look at sealed records. In addition, we authorize the Virginia DCJS to develop regulations as to certain types of employers that should be able to look behind sealed records. For some reason, DCJS didn't issue any regulations, which is not uncommon with this administration, but they still have the opportunity to issue regulations under the bill to broaden the categories of employers that are allowed to look. And So depending on the regs that are adopted, the answer to your questions may be. Yeah, Senator Peak.
Question for the witness.
Yeah.
If we don't pass this bill, are there a large number of felonies such as sexual crimes that will not be sealed if this does not pass?
That will be sealed.
Mr. Chair, Senator
That
Peake.
will be sealed if we don't pass this? What are some of those sex crimes?
That is correct.
Which ones, Mr. Chair?
All of them.
Tell me a few.
Right now, we have all misdemeanors and all Class 5 and all Class 6 felonies that would be eligible for sealing. So there are some registerable offenses required by the sex offender registry.
All right, thank you.
Any other questions? No other questions. Okay, Deeds moves and Boysko seconds that the bill be reported and re-referred to finance. Clerk, open the roll.
Ayes 10, noes 5.
All right. Bill reports refers to finance. Now we have House Bill 2729 by Hope. This has to do with judges in judicial districts. It is similar to Senate Bill 1327 by Diggs. I believe Hope's bill basically, Hope's over there. It codified the recommendations of the study. You already told me. Diggs's bill basically only codifies the positions that have been certified by the Judicial Council and the District Court Committee. And Hope and I have discussed conforming his bill to Diggs. And going forward, while JLARC looks at the National Court Center study, that we only add new positions that are certified by the Judicial Council and the District Court Committee through their normal process. That's what we've talked about. So Deeds moves and Boysko seconds that the bill be conformed to Diggs. All those in favor say aye. Aye. Anybody opposed? No. Okay. Open chains opposed. Nobody else? Okay. All right. The bill's conformed. Deeds moves, Boysko seconds, the bill be reported and re-referred to finance. Clerk will open the roll.
Ayes 14, noes 1.
I should. About the judges? Oh, that. Oh, Deeds wants to talk about it on the floor. Okay. I did miss that. Okay. 2730, Hope. We didn't talk about this. Why don't you come up here? Come on up. We got 2730 by Hope, which is another Crime Commission bill. This has to do with the Mary Jane Burton situation. The Senate bill only limited the study to people who are currently incarcerated. The review of cases to people who are currently incarcerated, not people that are out. I'm not sure what your position is on that. You and I have not talked about it. The Finance Committee did that amendment without talking to me. What do you want to do?
Shouldn't it be broader for people that want to exonerate themselves, be they're on a registry or hard for them to get a job? So my bill takes a broader approach. I think if we have the resources, we should.
Okay, sounds like we're going to conference. So, okay, so Deeds moves and Boysko seconds that we conform it to my bill, which I'm sure the Finance Committee do if I don't. And so all those in favor say aye. Aye. Anybody opposed? No. Okay, so Deeds moves and Boysko seconds, bill be reported, re-referred to finance. No questions. Clerk will open the roll. I hope we're going to conference.
Ayes 15, no 0.
I did say, I did. Hey, come on, man. I resolved 2 conference committees this weekend that I'm not going to have. I didn't realize this one was coming. Okay, bill reports refers to finance. Okay, now, we are on similar bills where there's some thought maybe we might go with a House approach. So, House Bill 5097 by Feggins has to do with secure storage of firearms and penalties. However, it also includes a bill similar to Delegate Laufer's bill that the same committee also passed. So the committee passed 2 different policies on the same policy. And similar to a bill we passed. Feggins, come on up. Yeah, I did. So, Feggins, your storage piece is similar to Boysko's 1134, and your guns and cars piece is similar to a bill we passed last year by Marsden, which he elected not to introduce this year, and instead went with an entirely different approach. Your bill also has language that law first has, but has different language on the car piece. Is Lawfer here? There she is. Are we PBing on your bill? Is that what we're doing? You guys talked?
We did talk.
You guys figured out what we're doing here?
Well, I mean, I would just say that I realized his Marsden's bill is similar to a portion of his bill. So, my bill was a civil penalty for guns left in cars in view. And Delegate Fagan's bill is more about the storage in a lockbox, which is similar to Marsden's bill.
Okay, so it doesn't sound like we figured out exactly what to do yet? Is that right?
Well, I understand that there might be a challenge with this, so. But I would just say that the police department by me asked me to bring this bill forward, which
Yeah.
is part of why I brought it again this year. So we could maybe put the civil penalty into Delegate Fagan's bill, or,
So you guys haven't figured out what to do yet?
well, I understand, well,
Okay, why don't you guys go in the corner and,
I don't want to say that out loud.
yeah,
Before they do that.
it bagged me good.
Can we hear from staff to see what that looks like?
What looks like?
Rolling in the penalty.
Can you do that?
Well,
I think that's what
Fegan's
you
and Lawfer's bill contain policies on the exact same subject matter, but they're different, right? You need to be on mic, yeah.
Mr. Chair, Delegate Fagan's bill has the Class 1 misdemeanor if the gun is left unattended in a vehicle and then taken by someone else. Delegate Loeffler's makes it a civil penalty to leave a firearm in the car unattended. So they're similar but different.
And Chair, I did sit down with Senator Marsden's on Friday to talk about the CCP portion of his bill, and he did state that he would be comfortable with conforming it into mine, adding that portion.
Glad he told me. So, let's see. Your Lawfer's bill has to do with taking the gun, and Fagan, I got it backwards. Lawfer's bill has to do with being in plain view, and Fagan's bill has to do with taking it?
Chair, mine is strictly about secure storage in terms of house, secure storage at home, and then the educational portion of it, so.
Right, I get you got the bill that's similar to Boysko's, but you've added this part about cars, which is identical or similar to Lawfer's language about cars. It's like they took Marsden's statute and grafted it onto your bill about cars and mixed up houses and cars together, right? Right? And it's very similar to language in Lawfer's bill, very similar, just the penalty's different. Well, that's what I asked last night at 10:30 when I figured this out, but we can't pass by today, I have to go to finance. That's why somebody needs to go in a corner and figure it all out and come back to me, that's what I
Pass it by
suggest.
temporarily, see if
Yeah.
we can find Marsden and y'all can
Ask
figure
one
out.
question before they-
Yeah, can you guys go try to find
18.3,
Marsden, do all that?
8.7,
Yes, and Bagby has a question.
I just have one question for you, Mr. Chair.
Yeah.
How is this different? I think you said it, but I missed it. How is Fagan's bill different than Boysko's bill?
The house piece of it?
Or maybe Boysko or Fagan's.
The Boysko's only has to do with houses, but is that part different?
The language is, Mr. Chair, the language is slightly different. My understanding is that the House was hoping that Fagan's bill would move forward on its own. Mine is a slightly different approach that we have passed through both bodies and was vetoed by the governor last year. We talked about this last fall before we both filed our bills, and both of us agreed that we would be carrying slightly different versions of it. I know that this Delegate Fagan's bill is a priority for the House.
Still, it sounds like we need to have a full hearing on it if it's different. So why don't you all go in a corner, see if you can find Marsden, see if you guys can figure out how to split all this back in a way that makes sense, because we can't pass two bills that have identical language with totally different approaches, with different penalties. We have to pick an approach. This happened last year with Nadarius Clark and Delegate McClure on another bill. And so see if you can find Marsden. We're going to be here another 2.5 hours, so thanks. Okay, and then, so we're going to skip Lawfer. Next up, I've got House Bill 1730 by Delaney, which is similar to Senate Bill 894 by Perry. This has to do with the civil liability to an employer of a vulnerable victim, assault and battery and rape. My understanding, Delaney, is she here? There she is, that there's some kind of an amendment offered by you.
Yes, Mr. Chair. We've continuously kind of worked to address some of the concerns on this bill, and we do have an amendment.
The amendment in the package?
Mr. Chair, yes.
Oh, I got it, okay.
It is.
Okay.
It's on line 9.
Okay, so we're excluding public transit agencies funded in whole or in part by the Commonwealth Mass Transit Fund from the bill. Is that right?
Yes, Mr.
Okay,
Chair.
I heard somebody on my left say why.
Mr. Chair, I think it helps us tailor the scope of this bill to the crimes. Is this, am I too quiet in this? There we go. It helps us tailor the scope of this bill to the crimes that we are really attempting to remedy through this solution, and want to try to get as much support for this as possible so that it has the best chance to be signed into law. And there's more answers here.
Okay, Albo. I remember Delegate McQuinn had a bill last year that had to do with transit workers getting assaulted on the Richmond bus system, and she was unhappy about that. Is there something to do with that, or?
So, Dave Alba representing WMATA Metro.
Oh, okay.
As the bill progressed, it added in common carriers, which includes Metro buses and public transit. Our attorneys at Metro said that it possibly does two things. Number one, eliminates sovereign immunity because you're specifically including it in this bill. And number two, you remember that Metro is a compact of DC, Maryland, and Virginia. And we can't alter the compact without having all three agree. And so the solution was just to exempt public transit, which would be government-owned transit.
But can't you just reference the compact instead of every single transit agency in the state?
Yeah.
Couldn't you do that?
You could. I mean, as far as my client's concerned, that's fine. I'm sure there's other people who wouldn't like it, but.
Sure, but I understand that the compact is an issue, altering the compact. I can see that, but you're not waiving sovereign immunity on that because it'd be a violation of the compact. I'm not even sure we have the authority to do it without the other people agreeing to it.
I'm not sure it's a waiver.
Yeah, I'm not sure either. But it seems to me that's probably a tighter way to do it than exempting every single transit agency in the state.
Certainly.
Yeah.
Do it and talk about it.
Sabrina, do you know how to do that? Do you know how to reference the compact by statute? I think it's in the code.
I could figure it out, Mr. Chair.
It's on LIS. What does the committee think? Does the committee think that's a better approach, or should we say every single bus system in the states? Open chain like scenario approach that I suggested.
Mr. Chair, there is a whole code section in the compact. I don't remember what the citation is, but you can just cite that. Any public transit pursuant to section.
Yeah, no, the old LIS used to have compacts on the homepage, and now I don't know where they buried it, but it used to be easy to find. Sounds like.
Thank you. That's my bill. I like the approach.
The narrow approach.
The narrow approach.
Okay, so Open Chain moves and Perry seconds that we amend the bill to exempt WMATA by specifically referencing the compact and code. Looks like Sabrina might have figured it out. Is that why you looked at me?
No, I was just making sure I was understanding what you mean.
Huh?
No, I have not figured it out. I'm sorry.
Okay, it's in the.
Yeah.
concept.
Oh, here's the compacts right here, yeah. Here, it's 33.2, 3100 is the compact, okay? Okay, so that's the motion. All those in favor say aye. Aye. Anybody opposed? No. Okay, so the bill as amended is now super close with that exception, right? Any further discussion about the bill? Okay, Dees moves and Boysko seconds that the bill be reported, and does this have to go to finance? Yeah, referred to finance. Clerk will open the roll.
Not re-referred, sir.
Huh? Oh, it goes to the floor, okay. Dees moves, Boysko seconds that the bill be reported. Clerk
Ayes 15, no zero.
Okay, bill reports. Now, I need the committee's attention on Maldonado, House Bill 2120. I think you guys want to pay attention to this. This has to do with seizure of property from financial exploitation. It's on the same theme as Favola's Senate Bill 825, but takes an entirely different approach. And Senator Favola would like to go with Delegate Maldonado's approach, but again, it's an entirely different approach. So I need the committee to look at the bill. Yeah. So
We like Senate approaches.
that's what I thought too. So Delegate Maldonado, Favola would like to speak before Maldonado talks, I think.
I think the delegate has a line amendment.
We do have line amendments, Mr. Chair.
Okay, well, why don't you first of all explain how your approach is different, and then we'll talk about your line amendment, because it's it's a totally different approach.
Yes, Mr. Chair, good morning. Good morning, members of the committee. Our line amendment, the approach is one that is more succinct, we're hoping. We got to this place working together, Senator Favola, myself, and one of our amazing detectives whose job it is to help protect seniors. This is part 2 of our elder financial exploitation work that passed last year. And what we're trying to address is when there is an instance that our elders or vulnerable adults are the victims of financial exploitation, a number of our law enforcement feel that their hands are tied to be able to hold and protect those assets. This gives a mechanism for them to do that.
Right, we got that part, but why is your approach better than, beside the fact that it uses less words, why is it better than Favola's?
It wraps into our existing seizure laws versus the approach we had before. We incorporated into what's already in the code to make it more streamlined and to make it easier to enforce. It really works with what we have already in the code.
Okay, Mr. Benjamin, did the work group have the opportunity to consider this approach, given that you weren't on notice that this was the approach we're going to take, or did you guys assume we're going to conform to the bill we already passed?
We assumed you would conform it.
Okay, so the bill has been looked at by our work group. So, Obenshain, go ahead.
So is this approach that can be utilized only after conviction?
No, this is during an investigation to help maintain and protect the assets. What is happening, as we're understanding on the ground from law enforcement, is that they will go through the investigation, but they're not able to seize and protect the funds during the investigation, so they get to the end and all the assets are depleted. So this helps them for a 21-day cycle to be able to hold and protect those assets.
Wasn't the approach that we took more directive and mandatory? Because I believe that part of the problem is that local law enforcement views these crimes as civil matters, and they just don't do anything, and these assets wind up being dissipated and making it subject to seizure just appears to be very optional. And I wonder whether that's a meaningful change in the status quo. I mean no harm. I supported the bill before, and I agree that it's a serious problem. I just want local law enforcement to actually do something.
Maldonado, I think Favola has a response to that, unless you want to take it first.
Yes, Mr. Chair.
Okay, Favola, go ahead.
Well, maybe somebody can explain this with more clarity, but this is the current seizure statute. And when I first presented my bill, I know we had a conversation about making the vulnerable adult section applicable to the current seizure statute. And that, in effect, is what she's doing, which is why we thought it was an easier, more streamlined approach, because we're dealing with statutory authorities that are already on the books.
Right, they're mainly used for drug crimes, though, I think, Perry, you have something?
I have a question.
Yeah.
I just have a question about the way that I saw Senator Favola's bill was that, hey, we are going to essentially mandate, or I don't even know if we ended up mandating, but law enforcement, hey, when you do a one of these vulnerable adult prosecutions, and then I think we ended up expanding it after the fact to, and I think that's the better approach. But when you do it, like, hey, you need to go seize this money so that it isn't pilfered away, the money that the person has taken from this individual or whatever other assets that they've taken from the vulnerable adult. Go seize it, make sure we have it in evidence. I'm not really clear on why law enforcement can't do that anyway, but that was sort of the code section. The way that I read your seizure forfeiture code section, it says all money, equipment, motor vehicles, and other personal or real property of any kind or character that is used to promote or engage in or that is the subject of the violation. So my question is, that seems to me much broader. I just went and I'm quickly looking at Senator Favola's bill, but it says you're talking about money or other assets. Like, you're really focused on sort of what, in my opinion, what was taken from the individual. The forfeiture bill reads more like a drug forfeiture, where I'm going to go take the car that the drug dealer drove in and things like that. Like, you're really dealing, in my opinion, in a totally different way. You're looking at the offender and taking their property. Is that fair?
Mr. Chair.
Yeah, go ahead, Delegate.
Thank you, Mr. Chair. I would respond that is part of why we submitted the line amendments today. We took out the line is used to promote or engage in, or that is this, and simply the line would read any kind or character that is the subject of a violation of 18.2-178.1, and the second line amendment inserts or that was purchased using the funds that were subject to such violation shall be subject to. So we were using the line amendments to get to be more narrow, to fit within existing sort of protocol, and also be able to have law enforcement who asked us to bring this bill forward to have the option to do that.
Mr. Chairman.
Yeah, go ahead, Senator Perry.
And the other thing I'll say is, and I didn't ever do seizures or forfeitures. I'm sorry, I didn't ever do forfeitures in the Commonwealth Attorney's Office. So I'm operating from a little bit of a deficit. But the way that they typically work is they trail behind the criminal case, because they're a civil case, and sort of what happens in the criminal case often drives what happens in that civil case. And once they are forfeited to the Commonwealth, once there's a hearing on whether or not they will be forfeited, then then the Commonwealth can do whatever it wants with them. I thought that part of the point of Senator Favola's bill was that we could get some of these funds back to these people earlier in the process. Have you, is that removed from this section now that it's part of the forfeiture provisions, or are you guys not worried about that anymore?
My understanding, Mr. Chair, is that there still is a 21-day turnaround cycle.
Sorry, your understanding is what?
My understanding is that there still is a 21-day turnaround cycle, so this isn't holding these assets indefinitely.
Okay, where does the forfeiture proceeds go?
Mr. Chair, they can be deposited in accordance with 18.2-178.1. Again, we were trying to make sure that we weren't creating.
Is that in your new language? Your language?
That's currently in there on line 15.
Right, but the existing drug seizure statute doesn't go to a victim. So,
Right. But, Mr. Chairman, I have another question.
Yeah.
Okay, going back to the 21 days, I'm referencing the statute that is referencing your bill, and what it says is, any action of forfeiture commenced under the section shall be stayed until the court in which the owner of the property or the person whose custody of the property is found to be prosecuted. Then after that is when the 21 days kicks in, which is what I'm referencing. This happens post-prosecution. That's subsection C of 19.2.386.1, which is what's referenced in your bill. And you guys can make a policy decision, right, that you want it to happen after the prosecution, but it has to be stayed. And I think that's separate from the other point that was made, for what that's worth.
Right. And I also got Peak and then Stewart in the queue.
Several questions. First, what's mutatis mutandis? I know.
Huh? It's something to do with taking your guns.
Good. I'm for it. And second,
hold on, mutatis mutandis. I'll ask Google why you're looking at mutatis.
Mr. Chair.
Mr. Chair, it means that the words are changed as necessary.
Used when comparing two or more cases or situations, making necessary alterations while not affecting the main point at issue.
thank you very much. Second question. Under Senator Favola's bill, can a civilian dupe initiate the seizure or the holding of property? Oh, she's not here now.
Yes.
There she is. Oh.
Favola, that's a question to you, Barbara. Favola.
Senator Favola, under your bill, can a civilian initiate the holding or seizure?
Under my original bill, the Commonwealth Attorney could petition and then get a seizure warrant and go ahead and
Mr.
move
Chairman.
forward.
Mr. Chairman.
Mr. Chair.
Yeah, Peak.
And under your understanding, Mr. Chair or counsel, didn't we amend it so that a private individual could
Yes.
initiate a proceeding?
Yes.
That's exactly right.
Right,
Okay.
right.
Under this, Mr. Chairman, under this bill, there's no method for a private citizen to initiate a proceeding.
It sounds like you're right, Peak.
Well, then that's rare. And then I think we need to make sure that a private citizen can initiate a proceeding. Because law enforcement's not going to know. Law enforcement, let's face it, if you call the police and say, I think somebody's stealing from my grandmother, that's not going to be the first case they get on. We need to have a private right of enforcement.
Mr. Chairman.
I had Stewart in Q2. Is that on this? Perry? Perry, is that on this?
Mr. Chairman.
Hey, Stewart.
Thank you, Mr. Chairman. Senator Peake covered much of what I wanted to, but as I understand the seizure law under 19.2, that would require a Commonwealth's attorney to do it, and there's a process set out for that. And I don't see that the assets would go back to the individual from whom they were taken in the event that they should, unless we amend this.
No, I'm looking at 30.
And Senator.
I'm looking at 19.2, 386.12, and it
Mr.
says
Chair?
the residue is paid, dispersed pursuant to subsection A of 38, 386.10 and 14, and regs promoted by the Criminal Justice Services Board, whatever that goes.
So there's a process for drug seizures, I should say the spoils of drug, whatever.
I think didn't we pass another bill that said that, didn't we pass a heads bill earlier this year that said that forfeited proceeds can be kept by the sheriff and used to promote or pay for expenses in the sheriff's office or something too? I mean,
related to something, but I can't remember what it was
Mr.
related
Chair?
to. The difference is in Senator Favola's bill, we worked pretty hard to allow either a petitioner who could be a family member or the authorities, the police, an investigator, a Commonwealth's attorney, to petition to have these assets seized, frozen, and then a process by which you would operate under with regard to that. So I don't dislike the delegate's bill, but I think Senator Favola's bill was a much better process for what they're trying to get to with these vulnerable adults.
Okay, Favola.
I'm going to defer to the delegate. I think your thoughtful questions may have moved the needle a bit on where we're going to end up.
Yes.
Okay, well, I'm hearing on my left that we probably ought to just conform this to the Senate bill, and if you guys
Yes.
continue to have problems, just work it out in conference, even though your approach is very, very different. And hold on a sec. I just want to make sure, though, I don't want some brand-new thing coming out that doesn't look like anything we've passed because that at a conference, because this is very technical stuff, and I think, and it's going to require, if we do something radically different, it's going to require some real work. So I heard somebody to my right want to conform. Who was that? Carol Foy? Carol Foy moves and Perry seconds that we conform the bill to Favola's bill. All those in favor say aye. Aye. Anybody opposed? No, okay, so the bill is amended. Before us, Deeds moves and Boyce seconds. We report and re-refer the bill to finance. Clerk will open the roll. Wow, even though it involves money, all right. Report the bill to the floor. Clerk will open the roll.
Ayes 15, no zero.
All right, Maldonado, you're.
Thank you, Mr. Chair.
Got some meetings ahead of you. All right, next up I have House Bill 2222 by Cousins, which has to do with restraining juveniles. I believe it's, what is it? Is it similar to Bagby?
Yes,
Identical, similar?
similar. So
So you want us to conform to your version?
Yes, and I believe Senator Bagby agreed to that.
Okay,
And
y'all
has
tell
already
us why?
conformed in the House. That happened on Friday.
Can y'all tell us why? What-
Yes, so in the original version of the bill, as introduced on lines 28 and 29, so sort of the last sentence of the bill, said that if such restraints are ordered, then it required the court to make written findings of fact in support of the order. That's JDR court. So OES raised some concerns that JDR is not a court of record. So in the House, we amended that to just require the court to communicate to the parties the basis of the decision to use restraints, either orally or in writing.
So you're saying that the only difference is the last sentence?
Yes.
Okay.
Mr. Chair?
Yeah, Senator Bagby.
I also want to make, because we made a lot of changes here in the committee, and those changes are already in Cousins' bill.
Okay.
Perry and, I think Stewart, I think we all worked on that bill and took some time on that bill, and so all those changes are in this bill.
Mr. Chairman?
That's correct.
Okay, who's that? Perry?
Yeah. If I could, I think we did talk about this whenever we were going through this, because, and I've heard this probably 5 different times this session, I don't know why, but that, if it's a court not a record, then there's nothing in writing. And that's just not entirely accurate. And I think the way the bill reads, at least what I'm pulling up on LAS now, and I know we've had some issues with it, but it says that the court shall communicate to the parties the basis of the decision, either orally or in writing. And so it gives the judge sort of that, discretionary factor. I mean, in plenty of cases, JDR, for instance, writes down what their ruling is as it relates to child custody or any number of things. So just because it's not a court of record does not mean that they don't sometimes put what they're deciding in writing. I just want that to be clear. So I'll be just totally honest. I don't really see an issue with it. They can do it orally or in writing. I think it's sort of a misnomer that courts not a record don't write.
Right, we did that on the protective order statute a couple of years ago. We said that if they're going to do it ex parte and not to use an affidavit, they have to write down the basis for their ruling in juvenile court, which is a court not a record. So I don't understand why the OAS would say that either, because it's inconsistent with what we've already passed and a lot of things, so.
Well, I think it's because of that code section that defines courts of record. And I mean,
Yeah.
clearly we all
Get it.
know about that,
But
which
that's not,
JDR's not there.
but JDR
so.
writes things down in their record
Yeah.
all the time.
I guess the way that it's written, maybe that their concern with the way that it was originally written is, the written finding of fact language. I guess maybe that applies to courts of record.
No.
Okay.
Mr. Chair?
Yeah, Bagby?
That may be a fight for another day. I think this bill is in good shape, and I'll move the report.
Second.
Appreciate that, Bagby. If there's judges that are ordering restraints on people, and that's a problem, I think putting it in writing might be a good thing, so they can be held accountable for it if they're ordering kids to be locked up constantly, and so we don't have some he said, she said about why the judge ordered it in the courtroom. So I think there might be good reasons to put it in writing, but if you all as the patron don't want a record about why kids are being put in restraints, I'm fine with that, but it seems to me it kind of contrary to the intent of the bill, but if that's what you all want, happy to pass it that way.
Mr. Chairman?
Yeah, Senator Stewart?
Can I ask a question? How would this practically work on a day in court? Can you explain that to me?
Sure. So so the judge, the sheriff, or so the judge or the CA could both sort of move, the judge sua sponte or the CA could move to sort of have this hearing about whether a child should be shackled or needs to be shackled in court without the child being present. So before the child is brought into the courtroom, the judge would then make a determination of whether the child should be restrained, using these determinations here.
Senator Stewart.
This was one of my concerns before. So you're holding that child in lockup until we can have this hearing? And we sort of addressed that in Senator Bagby's bill, I thought. Because one of my concerns is if they're bringing, and I don't really practice in juvenile court, but if they're bringing 10 juveniles in and you've got to have these hearings, all of them are going to be held in lockup until they can have them. So they're just going to move on with other stuff for the day, I suspect. And I thought we sort of addressed that in Senator Bagby's bill. Did we not?
Yeah, Mr. Chair.
Yeah, Senator Bagby.
I think what you will have is, on a norm, none of them being held because that's not a norm, and you won't see folks, or excuse me, you won't see sheriffs taking advantage of this piece of legislation. And so it would be a norm that they would not be held in the back. It'll be a norm that they would come out unshackled.
Mr. Chairman.
Senator Perry, is that Perry?
Yes,
Okay.
that's right. Mr. Chairman, Senator Stewart. Part B of the bill, it says instruments of restraint shall not be used on a juvenile during a delinquency proceeding in a juvenile and domestic relations district court unless someone makes a motion for it. And so I think on a typical day, what you would have, or what we're hoping you'll have, is kids who are not restrained, right? And then if someone wants them to be restrained, further, then they have to make a motion. And so I don't think it's that there will be a hearing on every single case for every single juvenile who's appearing, only if someone wants to move that the child needs to be shackled in the courtroom.
Okay. All right. Is everybody happy with where the bill is?
Got to have a motion to report.
I think we haven't conformed it yet. Or do we have? We don't have to conform it, right? There's no amendments either, right? We're just going to report the House version, going to conform yours on the other side. Okay. All right, so Deeds moves and Boyce seconds. They report the bill and does not need to go to finance. Clerk will open the roll.
Senator McDougal for Senator Obenshain.
Obenshain's got McDougal has him. Okay.
Ayes 14, no zero, abstentions
Reports.
1.
Okay. Next up, actually, I should probably tell the people out there what my order is. In the order I got Munden, King, Batten, then I have Kent, Helmer, he's not coming, I'm covering his, Bulliva, Hope, Eben, Williams, Hodges, Pillion, I'm sorry, Hodges. That's the order I got right now until we get to the other stuff. So next up, I got Munden, King, which has this vacatur thing for human trafficking, which is similar to Locke's 1460, 2393. There she is.
Good morning, Mr.
Good morning.
Chairman, members of the committee. Which one would you like to?
How are you different from Locke?
I'm sorry, could you
How is your
repeat
bill
that?
different from Locke?
The human trafficking bill up
Yep.
first? Okay. I believe there is a substitute. I'll let staff speak to the differences.
Mr. Chair, the only difference is a formatting issue with the title.
Okay, so we need to, is it a sub? Okay, we're reporting the House version, otherwise it's identical. It came out of here 12-0 to 2, Senate 40-0. It's been moved and seconded by Deeds and Boysko and a bunch of other people that we report the bill. And does it need to go to finance?
No, sir.
Does not need to go to finance. Clerk, open the roll.
Ayes 15, no zero.
All right, next up, I've got, I think that's it for you, right, Munden King?
That is correct. It
Okay.
is 2362.
Oh, you have another one?
Yes. Or is that not yours?
It is.
It is, but it's in a regular document.
Oh, yeah, we gotta wait on that.
I certainly will.
Well, actually, hold on a second. 2360, is that, did we report that unanimous last year?
Yes, it's a Boyd Grave bill that I
Didn't we,
believe
didn't we
came
report it
out.
last year unanimous out of this committee? Am I imagining things? Okay, sounds like it's a new bill, so we have to wait.
Is
then.
new one?
Yeah. Okay. Yeah, we got to take it up. We get this other stuff out of the way
Okay, thank
first.
you. I'll wait. Thank you.
Okay, sorry. Okay. Next up, I got Batten, 2472, juvenile fingerprints, palm prints. It is similar to Bagby's 1261, which passed unanimous. Yours is a little bit different, I guess. We're supposed to report yours. How's yours different than Bagby?
Thank you. Thank you, Mr. Chairman. There are small amendments that were made on the House side at the request of OES, just rearranging the word electronically. And that just is to reflect that the court is sending the disposition electronically to the CCRE and not to the local law enforcement agencies. And I have discussed this with the Senate patron, Senator Bagby.
Okay, and so we're going to conform Bagby's to yours on the other side?
No, we're gonna pass this one.
We're going to pass this one, but we're going to conform yours to hers. Okay, so Deeds moves and Boysko seconds that we report the bill. Clerk will open the roll.
Thank you.
Ayes 15, no zero.
All right, that's it for Batten. All right, next up, I've got similar bills. Kent, 1593, similar to Craig, 846. Doug Kent.
Good morning,
Good to
Chair.
see
I'll
you,
make this easy. I'd like to conform mine to Senator Craig's, to your version.
Okay, it's been moved and seconded by Deeds and Boysko and Bagby that we conform the bill. Those in favor say aye. Aye. Those opposed, no.
Report is amended.
The Senate bill came out 15-0, 40 to nothing. It's been moved and seconded. We report the bill. Clerk will open the roll.
Ayes 15, no zero.
Thank you so much.
Yep. Next up, I have Helmer, 1607, which is the AR-15 ban. It is very close to Deeds 1181.
Report is amended. It's not worth going to conference on. Report.
Second.
Move report.
Will you conforming yours on the other side? Yeah. Okay, Deeds moves and Boysko seconds. We report and refer the bill to Finance, unamended. And what's the difference?
The
Remember?
difference is the same thing. It's the same weakening amendment they made in the House last year. But that's what the House insists on, so we're going to let it go.
Okay, I don't think it's going to change anybody's vote here. Clerk will open the roll.
It allows you to carry.
Ayes 10, noes 5.
Okay, next up, I have Helmer 1608, which is, it's similar to Evans 1450, which is the firearm industry liability thing.
Vote no. Vote peak no on that one.
All right, you might want to communicate that. Or you're going to get peak of primary. So,
9-6.
So this is to do with the firearm liability. It's similar to Evans. I think we need to conform it to Evans. So Deeds moves and Boysko seconds that we conform it to Evans firearm liability bill. All those in favor say aye. Aye. Anybody opposed? No. Deeds moves, Boysko seconds. We report the bill, refer it to Finance. Clerk, open the roll. Okay, Bulova, where are you?
Good.
Okay, Bulova.
Ayes 9, no 6.
Thank you, MJ. Sorry, I'm going too fast. Okay, Bulova. 1711, you have the Mass Care Fund, which is similar to Marsden's 1492, which is a bill that I was supposed to not put in, but Dave did anyway. So why don't you tell us what's going on between these two bills?
All right. Thank you, Mr. Chairman. There are two differences, and this is just a matter of working with the stakeholders as we went through the process, and we're tightening this up. And so one is that originally you couldn't get access to the Mass Violence Care Fund for 3 years. We moved that to 2 years. So if you recall, the Virginia Victims Fund cuts off at 1 year. This just makes sure that there's less of a time difference between when you can get the reimbursement under the Virginia Victims Care Fund to the Mass Violence Care Fund. The other one is just an advisory committee that the Workers' Compensation Board would put together that would get together once a year just to see how the process is working and also the position of the fund.
Okay, and so everybody knows, this is a $10 million fund that's been funded and set up. The money's been sitting there. It has to do with providing reimbursement to people who are victims of mass violence. And there's been a work group studying this for the last, I think, 18 months or so. Marsden's bill came out of here unanimously, and then it went to the Senate, passed by for the day to be included in the budget, was not included in the budget. So it's more of a finance issue than an issue in this committee. So Deeds moves and Boyce seconds. The bill be reported, be referred to finance. Clerk will open the roll. And somebody has questions? No questions.
Ayes 15, no zero.
All right, see you, Bolivar.
Thank you,
That's
Mr.
it for you,
Chairman.
right? Oh, no, you have the other one at the end, right?
Not today, I don't think.
Oh, that's not up today? Okay, all right.
If it is, I'm in trouble, but.
I don't think so. No, it isn't. Okay, we'll see you on Wednesday. Okay, next up, I have House Bill 1946 by Hope, which has to do with retail tobacco products. It is part of this tobacco morass that was created last year. It is similar to Senate Bill 1060 by Eben and staff. You don't have it on my notes, but isn't it similar to the that last bill we passed, the last committee meeting we had with was it Peak? Yeah. So don't we need to put them all together? Don't we need to put them all together? You only have Eben on my list, but it was on the same statute, I thought, and I thought we were talking about Eben's had only the forfeiture, and then Peak had the civil penalty, and I think we need to put it all together as one, don't we? I hope we had 4 different bills filed about tobacco.
My bill is just confiscation only.
Yeah, French's, his is just.
His was school property only. Yeah, but Peak's dealt with the exact same statute. It just had an additional civil penalty. Evans only had the forfeiture, right? It was the same statute, right? We need to roll them all into one. So it'll be a civil penalty and a forfeiture. Okay? That's what we meant to do, but we didn't realize we had 4 different bills in the same subject
Yeah,
matter
you
until
sent
the
me
end.
4 bills over that courts.
We put them all together and some of them together.
Only
Okay.
one's going to survive.
Does that sound good to the committee? Okay. Deeds moves and Boyce seconds. We conform it to
Mr.
Evan
Chairman.
plus Peak. And before we vote that, McDougal has a question.
I do. How does anybody determine that this is the item that can be seized? I know for alcohol, we have provision that says it has weight by volume on the container, then it's presumed to be alcohol. And nobody's testing for tobacco. So we say no person less than 21 shall have any retail tobacco product. Can we put something in here that says, well, not unless we say it's a presumption label, Mr. Chairman. We do that for alcohol.
Right, but there's no presumption for tobacco in the code right now?
I don't think so.
I've never had a tobacco case.
And I've heard from people that they'll find it at schools, but nobody's testing it to determine it's tobacco, so it's making it not possible for them to seize it. I don't know if that's true or not, but that's what I've been told. It seems.
So what's your?
Well, I just think that we need to add a line saying it is presumed to be tobacco if the label calls it tobacco.
With that alcohol, it has to be sealed though, right?
Mm-hmm.
Yeah, the presumption only applies if it's a sealed container of alcohol. Once the container's open, the presumption no longer applies.
That's accurate.
Yeah, they pour it out, right? Yeah, right.
They don't see it, so.
Yeah, right. So you want to add a tobacco presumption,
So add a presumption that if it says tobacco, it is.
even if they've stuffed marijuana cigarettes inside of a tobacco cartridge.
Yeah, well, the penalty is
Well, I mean-
less for that anyway.
Yeah. They'll claim it's that.
Yeah.
Okay.
I'm just telling you, a real-life problem.
It is a real life problem. I agree with you about that. It's messy. So, okay, first of all, why don't we take up the first motion first, which was to conform them to the 2 bills, okay? All those in favor of conforming to Eben plus Peak, say aye. Aye. Anybody opposed? No. Okay, now we're going to talk about a tobacco presumption. Joanne or Sabrina, do you guys understand where that language comes from? And it's going to be not in a sealed container. If the label on the product says it's tobacco.
But Mr. Chairman.
Yeah.
I'm just looking
Great.
at the language in the statute, and I'm sorry, I'm trying to do this a little bit on the fly, but it says, shall not possess any retail tobacco product or hemp product intended for smoking as they're defined in 18.2 371.2. And if you look at 18.2 371.2, they do have definitions of those words, just like they said they would.
Yep.
And it says retail tobacco product means any product containing blah, 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 is derived of, including cigarette, any electronic smoking device, whatever. It goes through all these different things. Accessory retail tobacco includes any nicotine vapor product, as that term is defined in. So it goes ahead and gives a definition, but it doesn't seem to reference any sort of a labeling. It's more a description of cigar, pipe, tobacco, chewing tobacco, snuff. Something I don't know, snooze. I don't know.
Right, but that's what McDougall says the problem is, because right now the only way to prove it's tobacco is to send it to the state forensics laboratory on a very minor infraction and spend a lot of money testing it to prove it's tobacco. Otherwise, there's no way to prove it's tobacco or hemp or anything. So that's the whole point of the presumption statute, is to avoid the need to have it tested. And right?
Yeah, Mr. Chairman, yes. And in this penalty, it's the seizure of the contraband is the sole penalty, but nobody's going to seize it because you're not going to take something to send to the lab to determine whether you can destroy it. Because there's no way to determine it's tobacco.
Well,
Because we don't have that
Was there a
presumption.
presumption before we messed with it last year?
I don't know the answer to that.
Looks like Perry has another question.
No, I was just gonna say, I mean, no one is gonna send it to the lab, and I'm sure if the lab were here, if DFS were here, they would prefer that we not send tobacco to the lab. But I disagree with the fact that no one's gonna seize it because they're not gonna send it to the lab. They would still probably seize it and bring it to court and say, Judge, you decide if it's tobacco. Here's what I got.
But they're not doing
it. Yeah.
Mr. Chairman,
Yeah,
they're not
McDougall.
going to court. Because the only penalty for this is seizure.
No, but we just changed it to peaks to get a civil infraction.
Okay. Nobody's going to send something to the lab for civil court.
No, they're just going to bring the kid in and yell at him and then send him home.
Put the presumption that if it's got the package, it's
Okay, so McDougall wants this presumption sentence in. Looks like Perry has a comment.
My concern is just, I understand the idea behind it. My concern is, I think the point that was raised earlier, most of the tobacco cases that I prosecuted or whatever that had that sort of evidence, I mean, do you think there's an issue if it says it's a presumption that it's tobacco whenever they fold up their, the little thing in there, their marijuana cigarette is in there, or their marijuana cigarette laced with LSD? I mean, dippers.
Mr. Chairman, if you just say, for the purposes of this statute, if you put that in line D or E, if it's labeled tobacco, it's presumed to be tobacco.
Okay,
And I guess the kids could say, it wasn't tobacco, it's marijuana, I'm not guilty.
And then.
Yeah, but then they have to rebut the presumption because there's a presumption in the law.
Right.
I think that's good.
Even though rebuttal presumptions aren't constitutional under Commonwealth v. Yap, but we're not going to talk about that. Okay, it's been moved to say we had this presumption council. You guys, I think, know how to write it. Looks like Benjamin, you have something you want to say?
There is an existing presumption at 58.1-1017.2.
Hold on, 58.1 dash what?
1017.2.
1017.2. Sealed pack, prima facie. Oh, there it is. Sealed pack. It's unsealed, there's no presumption. But that's only for violations under 58.1, so we'd have to do a sentence to apply the presumption 58.1 to title.
That's right.
To 18, whatever we're putting this. 18.2. So we still need a sentence. Okay, so we're going to take that presumption. Got it? Okay, all those in favor say aye. Aye. Anybody opposed? No. Okay. It's been moved to report the bill as amended and refer to finance. Clean up what happened last year. Any other discussion? Hope, you anything you want to say? You've been very,
We're
very
going to conference.
persuasive.
We're going to conference. I just been enjoying the show.
Okay.
I don't want to make criminals out of these kids, so we're going to conference.
Okay. Yeah, Motley Crue made them famous. So, I think it was Motley Crue, right? Smoking in the boys' room? Yeah, right. Yeah. Okay, clerk will open the roll.
That wasn't their original song.
Senator. Ayes 15, no zeros.
Okay.
Thank you, Mr. Chairman.
Chugging along here. Next up, I got Williams, 2252. Decreasing probation period criteria minor reduction. It is similar to 936 by Craig. My understanding, I think this is your first time here, isn't it?
Today, yeah.
Welcome to the
This
committee.
year, yes.
Okay, welcome to the
Been
committee.
here before.
Go. Oh, you have? Oh, Ren, you grew a beard. and
I
whatnot.
did.
Yeah, you lost some weight. You lost some
Yeah,
weight. Looking
thank you.
good. Okay. All right. 2252. Yeah, tell me about it. All right. How's yours different from Delegate Craig or Senator Craig's?
It's very similar. In fact, it's so similar that I would be comfortable conforming it to Senator Craig's.
Okay, it's been moved and seconded. We conform. All those in favor say aye. Aye. Anybody opposed? Okay. And yeah, it reported unanimously at the Senate and this committee and the full Senate. So it's been moved and seconded. We report refer to finance. Clerk will open the roll.
Ayes
All right.
15, no zero.
All right. You're out of here.
Thank you, committee.
Good work. Take it easy. Okay, next up. Hodges, 2308.
All right.
Wants to take the fun out of nitrous.
Yes, sir. Thank you, Mr. Chairman.
Yeah, more beards. Yeah, beards are in this year. So it is similar to Pillion's 1361. What are you looking for us to do on that?
Actually, I'd like to put it into the Senate version that passed this chamber and pass that through and put it in the conference, Mr. Chairman.
Conference? What's the dispute about?
Sir?
I mean, all he does is adds 2 words to the code.
Well, I mean, basically, the House version gutted the ID requirement, which I think is very important. We've done this in pharmacy. We did it with dextromethorphan years ago with an ID requirement to purchase dextromethorphan, which has been very effective, and people don't realize dextromethorphan can be very harmful, and kids were, drinking it and causing major problems. And a simple ID requirement, because, the FDA was saying, states, you need to be proactive. We're going to take it off the market. And that's the only thing out there for cough and cold. So we've shown that can be very effective. The House had some concerns over that and gutted that. And basically only, in the end, added it to the list of what noxious chemicals, which kind of gutted the bill. So I'd like to get it back to the Senate version that Delegate Pillion had and get it in a conference so we can work this out.
Okay, so Deeds moves and Boyce goes seconds. We conform
Sorry,
it.
Senator.
Conform it. All those in favor say aye. Aye. Anybody opposed? Okay. Deeds moves and Boyce goes seconds. We report and we refer to finance, so you can go to conference.
Then go to conference.
Oh, straight report. I'm sorry. Straight report. Okay, bill will be reported. Clerk will open the roll.
Does yours say
Oh, I see. The blue.
Ayes 15, no zero.
The green is finance. Okay.
Thank you,
All right.
Mr.
See you,
Chairman.
Hodges. Okay. Anybody from the prior docket still? Fagans, have you figured out your situation yet with Lawfer?
Yes, we dealt with Lawfer. I'll figure that out.
All right. Come back on up before we get to the stuff we've never seen before. What are we going to do with you guys?
Chair, we have stated that Delegate Lawfer will be okay with my portion, with my bill moving forward and using that as the vehicle.
Okay, and yours is, your karst language is very different than Marsden's approach, and it does not need to be conformed to Marsden, because Marsden's just repeals the piece of the car statute, locking it up in a glove box. Yours is very different. So, you want us to work off, well, first of all, I guess that means that Lawfers needs to be PBI'd. Right, so Deeds moves, Boyce goes seconds, we PBI House Bill 1622. Clerk will open the roll.
Ayes 14, noes 1.
Okay, Deeds is looking out for his delegate. Or his Albemarle compadre. Then your bill now is 1597. And your bill, how is it different from Boy Scouts and how is it different from what we passed from Marsden last year?
Chair, I would defer to Senator Boysko to explain that the exact differences, but I would be amenable to Senator Boysko's portion, Chair, being folded into mine if that was.
Okay, that makes it easy.
Mr. Chair, I move that.
So Boysko moves and Deeds seconds that we conform the home storage piece to Boysko's. All those in favor say aye.
Aye.
Aye. Anybody opposed? No. So then, how is your car piece different than what Marsden passed last year, that we passed last year at Marsden?
Chair, I'm not familiar with Senator Marston's portion from last year, just from what he passed this year with the concealed portion. After discussing with Senator Marston, I would be amenable to taking the concealed portion and adding that line into my bill, Chair.
Okay, well, Marsden's bill from last year, I think, said that if you have a gun that's in the open in a car, it's a...
Civil penalties is the only difference. Mine does not have civil penalties.
Well, your bill here says you have to keep a gun in a car in a locked box or container.
Mr. Chairman?
Yes.
I
Who's
just have
that,
some-
Perry?
I just have some questions for the delegate about the language in 18238.7:2.
Okay, so we're looking in lines 38 through 53. Yeah, okay, go ahead.
And okay, so the way that I read this, it says, lockbox or container means a secure container that's fully enclosed, opaque, locked by a padlock, key lock, combination lock, or other similar locking device that renders the firearm inaccessible to anyone other than its owner or another authorized user. And in the case of a box or container used to store a pistol, so I guess my first question when I'm reading through this, we come to the word pistol, but previously we're using the word firearm. Do you mean a difference? And if so, why?
Chair, I would answer the senator that I do not mean a difference. It should be for firearms.
Okay, then I would move that.
But doesn't firearm include like a bigger gun than a handgun?
Well, firearm has many definitions in the code depending on which code section you're referencing. So it can mean a variety of different things, but I don't think in the same code section we should reference firearm and pistol.
Right.
And mean them to mean the same thing.
Yeah, I understand that, but also I think the intent behind his bill was that if you're going to have like a rifle, doesn't need to be in a hard-sided lock container. Only a pistol needs to be hard-sided. I think. Am I not reading this right? Or?
Chair, I would answer the senator that in terms of the majority of course, firearms that are carried are pistols in terms of being on person. The majority that are stolen right now that we're looking at are pistols, but the intent is that if a firearm is being transported in a vehicle and is not on a person, it needs to be stored securely, be that shotgun, long rifle, pistol.
Ms. Fry, go ahead.
Thank you, Mr. Chair. So the use of the word pistol is in the definition of locked box or container, and it is specifically for, and in the case of a box or container used to store a pistol, hard-sided. So it's describing the box for the definition.
Mr. Chairman?
Yeah, Perry.
I'm looking at 1823007.1 definitions, and it uses the word handgun. Handgun means any pistol or revolver or other firearm except a machine gun originally designed for blah, 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 and provides a definition. Like, I think when we start monkeying around with like pistol versus handgun versus firearm, like, I just think we need to be really careful about what it is we're describing, understand someone one day is gonna have to prove these elements of this statute. And so it matters what words we use. And I just don't think the word pistol, that's not the word that I typically see in a code section like this, and it doesn't make any sense to me, specifically when you reference that renders the firearm inaccessible. You're talking about two entirely different things, and even if you were going to reference just handguns, to Senator Serval's point, if he's right, which I don't know that he is, it sounds like you have, quite frankly, a different interpretation, but I think the word is handgun that you want to use.
Come on, line 42.
I'm not looking at the line section. Give me
Chair,
just a second.
Well, would a friendly amendment on line 42 of a handgun be
Pistol instead of handgun instead of pistol.
handgun instead of pistol be supported by the committee?
I think so. Yeah. Perry, is it?
Right, I would reference handgun, and you could even reference the code section that defines handgun, but handgun, I think, gives you a better idea. of what you're referencing, what you're looking for, because at least under 18.2, 307.1,
Okay.
that definition, which I think is probably in the same section, says that handgun means a pistol or revolver, and I assume you would also want to include a revolver in those things that should be in a box. So I think by using pistol, I think you're actually maybe excluding revolvers.
Chair, I would support a friendly amendment if that would be okay with the committee.
Well,
For
Hey,
handgun.
Bagby.
I mean, we have a substitute on the way anyway, right?
Eventually, yeah.
I don't know, do we have to do all of this piece by piece?
Yeah.
We didn't vote on the other parts. No.
We conformed to Boy Scout, now we're making other amendments. And eventually a sub will pop out. So I think right now the motion is just to swap out handgun for pistol,
Yes.
right? Okay, all those in favor say aye. Aye. Anybody opposed? No.
Mr.
Oh,
Chairman,
yeah, Perry,
I have another question.
go ahead.
If I keep reading down that section, and I mean no harm to the bill for what that is worth, and I apologize, Delegate Piggins. Where it says lockbox or container does not include the glove compartment of an unattended vehicle or the center console of an unattended vehicle unless such console has been specifically designed to securely store firearms. And so just going back to I guess, what do you mean by that? So for instance, in my car, I can lock my lockbox and put a code on it so that I don't know that it's specifically designed to store firearms, but it is specifically designed to make it relatively secure where it would be hard for someone to get into it without the code to get into the glove compartment in my car. And so I guess my next question is just, what do you mean by unless my glove box has been specifically designed to securely store the firearms?
Chair, I would answer the Senator that there are specific modules that are actually come from manufacturers. For example, within certain Ford vehicles where the center console is designed, in terms of being directly designed for storage of a firearm. When you're looking at a lot of glove boxes, especially working with partners and working with, talking with law enforcement, the storage of a glove box the standard glove box was never designed for most firearms. A screwdriver, of course, could pop it open. So this specifically talks about saying that it should be designed for the storage of a firearm.
Okay, counsel, I got a question. I get his answer, but Mr. Benjamin or Joanne, I mean, in Marsden's bill, we repealed the section that Delegate Athey added in 2010, saying you could store a gun in a glove box. So don't we need, because this is a different approach on that, don't we need to repeal that language like Marsden did, or else we're gonna have two statutes in conflict, right? This one says you have to store it in a box, but it can't be in a glove box. Then we have another bill that said, we have another statute that says you're allowed to keep it in a glove box.
Answer that immediately.
Okay, hold on a sec. Fagans, what do you think about putting Lawford's language on top of your car language? And then if we need to figure this out in conference, including the things I just talked about, that we do it that way? Because it strikes me there's some more complexity to this that we haven't quite thought through, that's gonna take us probably about 20 minutes to work through in here, which we don't have time for today.
Mr. Chairman,
Yes.
for what it's worth, I have some questions about Lawford's bill too, if that's what we're gonna do.
Well, I think maybe I'll put you on the conference and we can all talk about it together. Yeah?
What does unattended mean on?
Patron, you got an answer for that, what unattended vehicle is?
45?
Because I think all of them have the
What
unattended
does
vehicle
unattended
thing.
mean? I'm thinking specifically with the DUI law, and if you've got the keys in your pocket, is it actually unattended?
Senator, I would have to, Chair, I would have to talk to council in terms of the DUI portion, as I'm not familiar with that.
Well, he's not. He's just. We had a big argument about DUIs earlier, and
So what does unattended mean with regard to this statute? If you have the keys, is the vehicle unattended? You're in custody and control of it, according to case law.
I think DUI has to do with operation, not attendance. But
What does unattended mean?
yeah, the courts would probably have to figure that out. Is my guess. This council has a better answer, but Benjamin, you got a better idea?
What unattended means.
I don't
in
remember
this
any
bill.
cases defining what attended or unattended means. I can't think of any, but so I'm not sure there's an answer to your question, Stuart. Okay. Perry, it just strikes me that we talk about lawfare for another 20 minutes in here. We got a bunch of bills left and only. I'm worried about time. Yeah, right. Yeah, I agree. Okay, so Boysko moves and Deeds seconds that we conform the car language to lawfare language.
Move to report.
Wait, hold on a second. We haven't done that yet. Because Marsden's language isn't this anymore. It would be the old Marsden language if we took language. It would be the language, Marsden language from last year. Marsden's new version is totally different this year. So
Conform this bill to Marsden.
that piece of it, and okay. All those in favor say.
No.
All those in favor say. What? What? What, guys? All those in favor say aye. Aye. Anybody opposed? No. Okay, so now we have a Boysko lawfare bill that's now Fagan's bill that Perry still has questions about that we'll talk about in conference if this thing keeps on moving. Okay? All right. So Deeds moves and Boysko seconds that the bill be reported and be referred to finance. Clerk will open the roll.
Thank you, committee.
Ayes 8, no 6, abstentions 1.
Okay. See you later, Fagans. That's it for you, right? Okay, now, we're on to a bunch of bills we've never seen before. I think that covers everything we haven't seen before. We have about 12 bills left and about 2 hours. So,
I feel compelled to use it all.
I'm not compelled to use it all. So, I'm gonna defer to the sign up. So on the sign up, I've got Sullivan, Walker, Scott, Herring, Hayes, Reeser, Tran, Clark, Hernandez, Batten, Hodges, Campbell, Lawfer, Cousins, Jones, Henson, Carlson, King, Price, Watts, Fagans, Gamara, Williams, Simon, Maldonado. And I'm gonna call out the ones that have already had their bills heard. So that leaves us with Sullivan. Sullivan, you've got 1914 compensation wrongfully incarcerated people. This is a bill we've not seen before. And you're trying to amend a bill I passed years ago.
That's correct. That's part of what 1914. So this operates in the space where we deal with Virginians who've been wrongfully incarcerated, which is a fancy way of saying they went to prison, although they were innocent. This bill, just for context, frankly, I've been in this. I've done a number of bills in this space, Mr. Chair. But the reason I'm before you this year is I have two you'll see when later. They're not going to come through this committee. Hopefully, when you get to the floor. One is a gentleman named Gilbert Merritt who was convicted of murder. Turns out he didn't do it. Spent 20 years in prison. The other is a gentleman named Marvin Grimm, convicted of a heinous murder here in Richmond. He went to jail at age 20 and came out at age 65, 45 years in prison. So that's sort of the context of why I brought the bill. It does two things to this portion of our code. The first is it cleans up something we did last year, which added extra compensation for people who were wrongfully put on the sexual offender registry. This is at line. It's at line. I'm sorry, 26 and 27. that's been read by some people candidly. I think it's a reasonable interpretation that their change last year would have awarded extra compensation for being on the SOR even while in prison. What this does is, I think, do a better job of capturing our intent. Certainly it was my intent that it would apply only to time spent on the SOR after release for what that does to someone who's out in society while wrongfully on an SOR. So that's the first change. The other is the one you referred to, Mr. Chair. Back in 2018, you, along with Delegate Jones, amended and added Section 195.13, recognizing a sort of an enhanced compensation mechanism for wrongfully incarcerated people whose wrongful conviction resulted from intentional acts on the part of law enforcement. And if memory serves, Mr. Chair, you'll correct me if I'm wrong, this had to do with what was going on at the time was the infamous Norfolk 4 case. And the Norfolk 4 case was happening at that time, and so the General Assembly added that section which recognized a couple different things. One, it said in the case of an intentionally procured conviction, the General Assembly would double, or had the authority, it wasn't mandatory, had the authority to double the base award. We do these things based on number of years spent in prison. And then added paragraph B to 195.13, which said, but you only get your double award unless, you can't get it unless and until you sign a release, which of course makes some sense. But then says, but you got to also go to the locality and get a matching award from the locality. And at that time, I'm sure you'll remember this, Mr. Chair, the Norfolk 4 had been in litigation with the city of Norfolk, had a deal, and so it all sort of made sense. The reason I'm bringing this bill, Mr. Chair, is while this language made sense in the specific case of the Norfolk 4, I brought the bill as introduced because I don't think it makes sense going forward for other people like Mr. Grimm and like Mr. Merritt, who clearly were convicted on purpose, wrongfully convicted on purpose by law enforcement. And here are the reasons why, Mr. Chair. What this bill does is essentially gives localities a veto power over what this body can do. If a locality decides it doesn't want to participate in paying one of these people any money, we can't. We can't give the enhancement at least. If a locality, and this I could see happening, can't afford to participate, we can't give an enhanced award to any of these people. So if you do the math, what we recognized back in 2018 is that in a situation like this, someone wrongfully convicted should be entitled to, or we determined it was fair that they be awarded 4 times the base amount. In that particular case, it was two times from the General Assembly, 2 times from the City of Norfolk. But when you run the numbers and think about possible situations going forward, two of which I have now in front of the General Assembly, what the section as written now does is it gives either a locality veto power over whether we can do it, or what it does is it literally forces someone to go and sue the locality. And the whole purpose of this regime was to streamline things, make them more predictable, and do away with litigation, or at least give a better option to all parties than litigation. By all parties, I mean both the Commonwealth and the claimant. I didn't pick the 4 times out of the air. One of the things I would suggest to the committee is, in the civil context, our code is full of situations in which you can get treble damages, which of course is just a fancy word for triple damages. You can get treble damages if someone sells you bad drywall. You can get treble damages if someone misrepresents what your health club membership's gonna look like. You can get treble damages if someone sells you a watch, tells you it's from Switzerland, and it actually happens to be from China. Right. And the list goes on.
So basically what your bill does is it gets rid of compensating people on their sex offender registry while they're locked up. And it says that if it's intentional, willful, malicious misconduct, the locality no longer has to match.
That's what the bill as introduced did, yes. It would be the locality no longer has to match. Now, the House Appropriations Committee, the bill that has been sent over here, strikes the number 4 and leaves it as is, as in a doubling. And then as a sort of hedge, what it does is it adds, you'll see at line 64, a new paragraph, which essentially says, we can double it, but the release you sign won't release the locality. So it essentially says, if you want more, go sue the locality. And then it does away with paragraph B, which was the one that said, yeah, you can't get 4 times unless and until.
Where does it strike 4 times?
It strikes 4 times. If you look at, it leaves intact on line 80, may be up to or equal to the amount of such compensation. I had, in the introduced version, Mr. Chair, it said maybe up to or equal to 4 times the amount of such compensation. So it
Okay,
deleted
so the
that.
substitute doesn't show the deletion.
It does not show the deletion.
Yeah, okay.
So it leaves that portion of it intact, strikes paragraph B that made any of this subject to unless and until.
Stuart has a question.
And
for you.
lets you sue forces you to sue the locality.
Stuart has
Thank
a
you, Mr.
question.
Chairman. Delegate Sullivan, I had 2 questions, and forgive me, I'm trying to follow this, and I don't know if I got the amendments or the right page. I don't see where, I get the fact that you aren't requiring a release from the locality, and I don't know that I disagree with that, quite frankly, but I don't see where you're requiring a release from the Commonwealth and then maybe a credit for what they paid. So it would seem to me if you're going to pay this from anything from the Commonwealth, we should get a release from the Commonwealth, and there should be some credit against whatever they then go after the locality for. Is that in here, or am I just not finding it?
Mr. Chairman, Senator Stewart, yes, if you look at 195.12, which has conditions for compensation, it is existing law that as a condition for receiving any compensation, a person has to execute a release and waiver for ever releasing the Commonwealth or any instrumentality of it. That's at line 58. Which is why the notwithstanding language that the House Appropriations Committee added starting in 64 is required, Senator, because if we had only left it at 2 times and required them to sign a release of every of any instrumentality, that would have cut off any subsequent right to sue a locality. So that's in there.
Okay, any other questions? Peake, you got a question?
The 2 times, Mr. Chair, Senator Peake, it is existing law that, and you can find this at line 80, it says, such amount shall be in addition, if the General Assembly, if this is a situation of intentional conviction, it says, such amount shall be in addition to any compensation awarded under the base award and may be up to or equal to the amount of such compensation.
What line is that?
In the current version before you, it's line 80.
Well, that's not in the version that we've got. That's online.
I'm on line 80.
It is in 801, 195, 13.
I'm on 7980. Such amount shall be in addition to any compensation awarded pursuant to 81, 95, 11 may be up to or equal to the amount of such compensation.
That's the current law. Current law, which you put into place in 2018, is if it's intentional conduct, you can add that this body can award an amount up to or equal to an additional amount up to or equal, which is a fancy way of saying doubling.
And then, Mr. Chair,
yeah, Peake.
You had it before, but that is gone. That
Yeah.
is not in
It was in his original bill, and now it's in the sub. It's not there anymore because it wasn't part of the original statute, so it's not going to show.
Yeah, in my view, it's unfortunately gone, but it's gone.
So what we're talking about is again, his language cleaning up the piece. We're not paying people for being on the sex offender registry while they're in jail. Cleaning that piece up in the first part of the statute, and then secondly, we're not requiring a local match anymore. That's basically what you're doing, right?
We're not requiring a local match, but we are not stepping up and filling what would be a local match. Now, General Assembly could do
That's basically the 2 things your bill does is those 2 things.
Okay. So what Mr. Chair.
Yeah, Peake.
So what we have been debating is whether or not we're going to
require a local match.
To go back to the 4, or
Well, that,
I mean, it
that
came out.
would be fine with me, Senator.
Well,
We're
but he's
debating,
asking that,
we're
but it's-
debating whether we're going to require a local match for when somebody is willful, intentional, malicious.
Yeah.
In order to settle one of these.
Well, his bill came out 98-0 of the House.
Right.
Is that a good thing or a bad thing, Chairman?
I would think that we ought to, I don't think we ought to change it and send it back to the House. So I move to report.
Okay,
the
is there
substitute.
any other questions for the delegate? I know, I get it. Okay, is
Mr.
there
Chair?
anybody opposed to the bill? Any localities want to speak on this? Okay, doesn't look it. Okay. All right, been moved and reported, or moved and seconded, we report the bill and refer it to finance. Clerk will open the roll. It's really more of a money issue than anything. Okay.
Senator As 15, no zero.
Bill reports and goes to finance.
Thank you, Mr. Chair. Members of the committee.
Okay, next up, I've got Walker. Is Walker still here? He's not here. All right, then next up, I've got Scott. Is Delegate Scott here? Scott's not here. Next up, I got Herring. You ready? I'm ready. You ready? Okay. All right. Herring's got a little bill she wants to talk about. That's right. This has to do with license plates or something, right? Yes. All right. We haven't heard about this one. Okay, 2724, I believe you have a substitute, is that right?
Yes, Mr. Chair.
Okay, Deeds moves and Boyce seconds the substitute. All those in favor of the substitute say aye. Aye. Anybody opposed? No. The substitute is now before us. Delegate Herring, why don't you take it away?
Thank you, Mr. Chair and members of the committee. License plate readers are currently being used on our roads in Virginia without any regulation, oversight, or public reporting. Over 130 agencies use this technology in our state today. That means there are no privacy protections or guardrails beyond what each department chooses to place in their internal policies. Mr. Chair, I want to be clear. In order to push past misinformation alleging that this bill targets certain groups of people who, in fact, without this bill, would continue to live in a commonwealth with no privacy protections from license plate readers, regardless of who they are. HB 2724 places statutory limitations on the use of LPRs and provides permitting process for state police and localities to place on highways. This is an important action in creating a uniform policy across the Commonwealth as we track where those cameras are in use. It is important to note, currently, cameras are sitting abutting our highways and roads already. A 60,000-mile expansion is a misnomer, as many primary and secondary roads are covered by cameras on local and private land, while interstates become easy targets for human trafficking. In fact, one needs only to look at the Cardinal News article this morning, which lists law enforcement agencies who have placed cameras on or abutting our roadways. And in fact, they specifically talk about Southwest Virginia, where they are being used, and we have likely been recorded. Indeed, currently, with no state mandate restrictions in place, a camera could be placed on property abutting the highway without us knowing what data is being collected, how it is being used, and no requirements from our state that the data be destroyed and not shared. Simply, we can no longer afford to keep our heads in the sand, failing to put standards and limitations in place to protect people. This bill is a result of a year-long study by the Crime Commission, which involves stakeholders from the police to experts to advocacy groups, and included public hearings and a 50-state review. With the passage of this bill, Virginia will move from one of the most permissive states to one of the most restrictive in terms of data sharing with other states and the federal government. I believe that this bill strikes a balance between protecting people, the public safety, and recognizing the concerns for individual liberty and privacy. LPRs use image or videos from multiple cameras as well as a machine learning algorithms to read license plate numbers and automatically identify vehicles. They also collect data which is further processed and analyzed by matching it with integrated databases, security systems, traffic management systems, or parking management systems. They can be a powerful tool to enhance our public safety and officer safety while gaining valuable information. Currently, there's no legal limit to its use. Under the bill, the use would be limited to ongoing criminal investigations of violations of state law or local ordinance, human trafficking, which includes labor and sex trafficking, active missing person cases, and stolen license plates and stolen vehicles. The bill requires that law enforcement agencies must obtain a permit from VDOT before installing a license plate reader system on a state right-of-way. The bill set restrictions on data systems retention and sharing practices. Data will be required to be destroyed after 30 days unless it is needed for an ongoing investigation or prosecution. The bill requires agencies to develop and publish policies on the use of LPR and a requirement that the agency and state law enforcement must write and publicly publish annual usage reports. The bill is integrated with the Community Policing Act, meaning that the public will have monthly updates about usage and police interactions. It also requires the implementation of an audit trail to know who accesses and searches the system and verification of alerts before conducting traffic stops. The query of the data in the system must be based on a reasonable suspicion, not a mere hunch. And the data is related to at least one of the four listed purposes I outlined earlier. LPRs cannot be used for the purpose of interfering with individuals engaged in lawful activities or tracking individuals on the basis of content of lawfully protected speech. Misuse of the system would be a Class 1 misdemeanor. Mr. Chair, I do not take this bill lightly. There is overwhelming evidence that LPRs have been a useful tool in keeping Virginia safe. However, we do need to put safeguards in place now for their use and establish a transparent, accountable system for preventing them on our highways in order to move forward. There are law enforcement advocates and individuals here today to share their stories and expertise. In the packet, Mr. Chair, I don't know if it's been handed out, that's been provided to the members. There's letters from the Center for the National Exploited Children. Within the few years of their use of LPR systems with coordination with the police, 100 children have been able to be found and returned. There's a letter from the Safe House Project and the Virginia Sheriff's Association. Within our own General Assembly family, I will share that Delegate Hayes' father went missing, and with the help of the LPR system, police were able to locate him and bring him safely home. There are stories from Accomack County where stolen vehicles were found, and also a stolen vehicle with a missing person was actually located by LPR. Police were able to identify 6 vehicles involved in a shooting, and they've been able to have sufficient information for a search warrant where they found a firearm that was equipped with a device to turn it into a semi-automatic handgun and a fully loaded firearm. Mr. Chair, there are many more stories of individuals who have been found, and especially children. Our highways are used for human trafficking, and this bill will establish a transparent system. And Mr. Chair, I will yield to the committee for questions. I have Crime Commission with me, and as well as people.
Okay, thank you, Delegate and Leader Herring. I just want to also point out to people that the sub that's before you includes the feedback and input of, we already did it. We already did the substitute. It includes the feedback of a bunch of different, I know Salim, Favola, I can't remember if Carol Foy was part of this, but myself, there's a bunch of changes in the bill that came out of the House as a result of all that. Some cleanup of just some technical cleanup about cleaning up data collected or generated, which is, I think, more of a technical computer kind of thing. We also added language about, we limited the criminal investigation of violations of the Code of Virginia or local ordinances. So the queries have to be limited to those kinds of crimes. We have some information about the audit trail and the reporting that has to go, including the contracts with the vendors have to allow the local law enforcement agency, the state police, be notified if a third party attempts to access the records either by subpoena, warrant, or request, and then that has to also be part of the annual reporting. And there's also a new enactment clause on the end of information the Crime Commission is going to get to analyze this. So anyways, that's some of the stuff that got added.
Mr. Chairman.
And Carol Jordan's in the queue. Let me do her first, and I'll go to Carol Foy.
Thank you, Mr. Chair. Question for the patron. So in regard to this, and thank you for bringing something that has guardrails on it, because currently I know that there are none in Virginia, and this goes a long way to handling that. And this isn't a gotcha question, but I see there's several stats in the packet that were just received, but would you have any idea how many times that this technology has been used to save children or elderly folks or folks with dementia? Do we have any statistics on that? Because I know it does great things, but I think that adds impact to what this does.
And thank you so much for that as a question, Senator, and Mr. Chair and Senator. I will say I don't have exact stats on it. I could just have national stats about the 100 children. There are stories right here in Virginia. I have police officers here to share that story, but it is a very useful tool. And it's a very useful tool. It has been used in catching people who have shot an individual in the leg, I believe in Charlottesville, and they were able to locate that individual by the use of the LPR. Thank you.
Mr. Chairman, I have a question for the Crime Commission, if the Crime Commission is here.
Yes.
I got Stuart Naird in the queue after that. I see it. Computer
Mr.
works.
Chairman, I have a few questions.
Yeah, go ahead, go.
Okay.
Go.
My first question is that, isn't it true that this bill will authorize 60,000 miles of highway roads to be used for automated license plate readers?
Mr. Chair, members of the committee, Kristen Howard, Director of the Virginia State Crime Commission. Yes, this bill does permit the installation of ALPR readers on the VDOT maintained right-of-ways, which are currently not permitted. However, if you have a right-of-way, for example, this podium, and the road is here, and this is private property, that ALPR reader could be installed right here. It's that right-of-way area that is not permitted right now.
Right, and Chris, and hold on, Carol, but the reality is that most of these secondary roads are so tight, they can be stuck all over Taco Bells or banks or whatever, and these secondary roads are pretty much already under surveillance, or capable of being under surveillance. It's the interstates, which is only about 1,000 miles, where you actually need access to the right-of-way to actually get something that can see a plate. Is that a fair statement?
Well, it's our understanding that the right-of-ways really do vary based on whether it's the primary or secondary or the interstate. We have VDOT here that can help provide some clarity to exactly what that looks like, but it's not a clear 10 feet, 15 feet. It will vary by the type of road and the location.
Okay, Carol Foy was asking you questions. Go ahead, Carol Foy.
Isn't it true that when we talk about automated license plate readers?
Microphone, so they can hear you on the outside. Mike.
Thank you. Isn't it true that when we're talking about the ALPRs, that we're not just talking about fixed locations? They can also be placed on vehicles. Isn't that correct?
Mr. Chair, absolutely, that is correct. They are in patrol vehicles as it stands now. So those highways that you referenced, you may have law enforcement officers in patrol vehicles on all of these roads with ALPR readers already installed in their vehicles, and you may have them in mobile units as well, or the mounted.
Follow up, Mr. Chair.
Go ahead, Carol Foy.
Isn't it true that ICE can subpoena this information?
Mr. Chair, I'm not an immigration specialist. I would defer to someone who's more familiar with immigration and federal law.
Follow up, Mr. Chair.
Go ahead.
But isn't it true that pretty much anyone can subpoena the information? Is that correct?
It's our understanding, and it's in the bill, that there is a subpoena provision that is allowed for this information and approved by the court.
Okay.
Right.
Follow up, Mr. Chair.
Hold on a sec. Counsel, Benjamin, Joanne, are you all know of any way that we can just put by code that we're not going to honor a subpoena, like by statute?
No, Mr. Chairman.
Okay. Right. Right.
Just that, no.
Right. Okay. Okay. Let's make sure. Go ahead, Carol Foy.
Okay, follow up. Isn't it true that a state that has criminalized abortion could potentially subpoena the information of one of their residents who have traveled into Virginia, where it is legal and lawful to have an abortion, to track that person? They could subpoena that. Isn't that correct?
Mr. Chair, the LPRs do not track individual information. They only have information pertaining to the vehicle, so there would be no information stored about individuals in an ALPR. Would defer to someone who maybe is more familiar with the abortion laws to handle that portion, but the ALPRs do not have individual information.
Follow up, Mr. Chairman.
Go ahead, Carol Floyd.
So if they have the individual's vehicle description or license plate number, then they can actually subpoena the information to track the person who come into Virginia for legal, lawful abortion care and subpoena the location, date, information where that person has gone in Virginia, correct?
I believe the answer is a maybe, because that individual would have to be querying that information for a permitted reason in subsection D. A law enforcement officer would not be allowed to just simply query the system unless there was a criminal
Right.
investigation
So-
or permitted
Follow up,
purpose.
Mr. Chair.
Hold on. So Benjamin or Joanne, if some prosecutor out of state wanted to subpoena information in Virginia, there's some process they have to go through to issue the subpoena and get it recognized in the Commonwealth, right?
Yes.
And there's some court process in Virginia where, does the Attorney General deal with that, or the local prosecutor?
Mr. Chair.
Hold on, I'm going to answer my legal question
A
here.
subpoena, Mr. Chairman, a subpoena from out of state would have to be domesticated pursuant to the Uniform Interstate Deposition and Discovery Act.
Okay, how long does that typically take?
Sorry, what was your question?
How long does that typically take to play out?
Oh, it depends from state to state. It can be very efficiently done. What it requires is that the subpoena be issued by the issuing state and by a court of the issuing state. That subpoena, once it's issued by the issuing state, then comes to a circuit court in Virginia, which is supposed to then issue the Virginia counterpart.
Right, my point is, how long does it take typically for a subpoena to come from out of state, come here, get docketed, domesticated, whatever, finally get served? I mean, I would say on average, it probably takes a matter of weeks, if not
No,
months,
not
right?
necessarily, Mr. Chairman. It could be accomplished within a week.
Within a week?
Yes, sir.
Okay, and the retention period on this is only 30 days, so in terms of it catching up with the data, there's some kind of a lag in there, just want to point out. Okay, go ahead, Carol Foy. We need to move this along, though. We got a lot of bills left, and we only got an hour and a half.
I understand, Mr. Chair. Follow up.
Go ahead.
Isn't it true that there are no guardrails to prevent a concentration of these ALPRs from being deployed and mounted in majority Black and brown communities, creating a disparate impact?
Mr. Chair,
Yeah, go ahead.
currently there are no guardrails about where their placement is for the Commonwealth right now as it stands. This bill would provide numerous guardrails. There are no guidance provided as to the location of the ALPRs.
Last follow-up, Mr. Chair.
Go ahead.
Didn't the Virginia Crime Commission actually note that ALPRs can lead to disparate impacts on minority communities?
Mr. Chair, yes, that is an accurate statement. When we met with different stakeholders, that is something that was concern that they brought to us. As mentioned before with some of the success stories, a lot of the information that we have is anecdotal, and we don't have any data at this point because we're not collecting anything and no one is reporting anything. So right now, everything is anecdotal. We have some data and reporting requirements in this legislation that would hope provide some information down the road for that.
Thank you.
And then I got
Mr.
aired.
Just really quick, my understanding, aside from the subpoena issue, is that you collect the data, it's stored for 30 days, and then it's destroyed. But is it a provider, a business that does this for law enforcement, I assume? Do they have access to that data, or do only law enforcement have access to that data?
Mr. Chair, it's our understanding that the vendor will have access to that information. They're going to be using that system to better analyze the photos so that their technology can get better. But after that 30 days, they also have to destroy everything as well. There is an audit trail that is maintained for a 2-year period, which is separate and apart from the images. So there's 2 different types of data that are maintained by the systems. We've got some vendors here. It will vary by vendor as far as how their systems operate, but we made some protections in the bill so the vendor must also comply with the law enforcement agency for the 30 days.
So, Mr. Chairman.
Yeah.
So I guess then my only question would be, what safeguards do you have in place with the vendor to make sure that the vendors don't misuse this?
Certainly. We have worked with the Department of General Services to have an approval process for the vendors and certify a number of different criteria that they must meet before they can be authorized to be a vendor approved to operate in the Commonwealth. And so that way they have a review process. They're working with VITA as well to make sure that their IT standards are in compliance as well. And so the bill does address certain requirements, and they must be in compliance with all of the
Right. Lines 58
statute.
through 77, and it parallels the process we use for radar, LiDAR, and also facial recognition technology with additional standards for LPRs.
Yeah. I just wanted to hear them say it, Mr. Chair.
Okay.
Thank you.
All right, Aaron, are you still in the queue? I can't quite tell from
Yeah,
the
I just
computer.
have,
Okay.
Mr. Chair, one question for Kirsten and then one question for the patron. I was just hoping you could further clarify how, within the substitute that's been adopted, we ensure that the data collected only remains in Virginia and cannot be utilized outside of Virginia.
Absolutely, Mr. Chair, members of the commission. Subsection D, we did make an amendment to make that very clear that the purposes that were permittable for part of a criminal investigation could only be used for alleged violations in the Code of Virginia and localities. We also defined law enforcement officer as part of the definition in 9.1101 that limits the definition for law enforcement agency to just those law enforcement entities. We've also added some information that requires the uploading of databases and information, so that way it cannot go to outside other states or federal databases or commercial or private databases as well. So we've added some
Follow-up question,
additional
Mr. Chair.
protections.
Okay,
So just to
and
make
Senator Ed, we also, just to follow on that, we also added language that if the company is subpoenaed for data, they're required to notify the locality that they've received a subpoena, and they're also required, the locality is required to include in their annual report whether they've been notified that their data was subpoenaed from the third party.
So, Mr. Chair,
Go ahead.
essentially, the only instance where another agency or an entity outside of Virginia could have access to this data is if the data is subpoenaed. Is that correct?
I think that's
Or a
right.
search warrant.
If you look at lines 107 to 108, I think that also confirms that. It says, a law enforcement agency shall not share the system data or audit trail data or disseminate such data to any database of any other state, federal, private, or commercial entity. And I think there's a different language in a different part with regard to the vendor not sharing the data with anybody else. So I think you're right.
And so, Mr. Chair,
And we put in language in the bill last night to make it clear that if a subpoena is received by anybody, they have to notify the local law enforcement agencies. So they have an opportunity to move to quash the subpoena or fight that if a subpoena happens.
and so, Mr. Chair, I don't know if this is a question for Kristen or Mr. Benjamin, but as to the description provided earlier around the timeline to act upon when the subpoena is received, is it factual that you would need to retain data longer than 7 days? I'm trying to understand, Mr. Chair, the harm in limiting retaining data at the 7-day marker versus what we have in the substitute at 30 days.
Yeah, I don't think that had to do with the subpoena issue. I think it had more to do with the fact that law enforcement wanted data for 30 days to be able to query it and use it, because sometimes you don't know if a crime's been committed until weeks later. And 7 days is not a whole lot, and 30 days is one of the shortest retention periods in the country. That's my impression as to the thinking behind the 30 days, but I don't, Ms. Howard can, or Delegate Herring can.
You're correct.
Final question for the patron.
Go ahead.
I think we have shared today how important it is to have access to license plate readers for law enforcement purposes and various other purposes. I don't think that's the question here. I think the conversation is about making sure we have the right guardrails in place. In the substitute, I believe we add language to require the Crime Commission to provide reports after or upon 2027, I believe, beginning those reports. My question to you is, what do you see the harm in allowing us to move forward guardrails for the existing cameras that are already operational and delaying expansion to right-of-ways until after we have an opportunity to assess after 2027 how these guardrails are working.
Thank you for that question, Mr. Chair and Senator Aird. My concern with delaying for the right-of-ways is that I think we are ignoring the positive impact that LPRs have. And I'm going to focus on sex trafficking, and from my experience as a guardian ad litem. And our highways are being used to traffic individuals. I understand that this is a process, and so, of course, it's the will of the committee what you want to do. But I think that we would have better data collection if we had it on right-of-ways. I appreciate and I'm grateful that you all recognize that we did work to put guardrails in and protections. But I prefer not to limit its use, because the reality is, no disrespect, but law enforcement has found ways. And when I drive down 95, I see them in areas where, it's not exactly the right of way, but it's pretty darn close. And so they exist. They exist, as you heard, in cars. I know in Alexandria, sometimes they're parked. And I prefer that we not limit the expansion, and that we're allowing the right-of-way placement, because we also need to know, how far there may not be a right-of-way placement. Who knows? But the reality is, as I said, it could be. I do know that our highways are used for sex trafficking as well as other activity, and I think it's better not to have a dark zone, so.
To be a little more direct,
Yeah.
Doug, the other thing, what I would say, and correct me if I'm wrong, right now, this data that's being gathered first of all, cities and towns have zero restriction on where they can put them, towns over a certain size.
Right.
So they already exist all over cities and towns. They exist on many secondary roads already, albeit not on a right-of-way. And there was also some that were placed in right-of-ways before the Attorney General put out an opinion saying they didn't think they were allowed in right-of-ways. So they're already being used all over the state, hundreds of these things. And the data is completely unregulated. It can be shared with anybody, any place, anytime, anywhere, given to the feds, given to anybody. And law enforcement has said, if you want restrictions on this, then expand it to the right-of-ways. And so if we don't expand it, then the law enforcement side of it is why would they want the regulation?
Better said than I did. That's exactly.
It's a trade-off here, and it's a balance that we're trying to hit. And I think that's what's going on here.
Exactly. Thank you, Mr. Chair. That's exactly, you said it better than me. And they're there. If we just open our eyes and look, you'll see them.
Yeah.
And that's concerning to me. And I think it's our obligation as lawmakers to put guardrails, put restrictions. And yes, I'll be quiet.
That's right. I got Peak, Jordan, Boysko, Favola, and I haven't taken any public input yet. And we got a long docket. Peak.
Yeah, and Mr. Chair, you covered a part of it, so question to the patron. These things, LPRs, are being used across the Commonwealth as we sit, correct?
That is correct.
Then, Mr. Chair or Council, is there any bill in the General Assembly this year to outlaw the use of LPRs?
Nope.
So, LPR, Mr. Chair, patron, the LPRs are going to continue to be used without restriction, without any guidelines, without any guidance from the General Assembly unless we pass your bill. Is that correct?
Yes, Senator.
Okay. Mr. Chair, we all know where we stand on these things. Let's limit the debate and get moving with this thing. Please.
Jordan.
Thank you, Mr. Chair, for letting me ask one question. Question for the patron, or either our counsel extraordinaire, Mr. Benjamin, I'm not sure who may know the answer to this, but as it sits in Virginia right now, if you're traveling on our roads and you have an easy pass, are any of those records not already FOIable or subpoenable in Virginia?
Right, they are.
Okay, so we, follow-up question, Mr. Chair. So, question to Delegate Herring. So, the heartburn over people worried about someone getting access to their records was shot out the window a long time ago. I would imagine when we put easy passes on cars. Would that be correct?
That is true. It can be subpoenaed.
Thank you, Mr. Chair.
Okay, I got Boysko next, then Favola.
Thank you, Mr. Chair. I was wondering if anybody from one of the localities who already uses the system, I know that the city of Charlottesville has a 7-day retention. I'm wondering if we could hear from them to see what their perspective is.
I know there's some people that were going to testify in favor. I don't
Right.
want to.
I
Can
just
you be
wanted
quick?
Just to hear
Charlottesville?
on that specific, on the timeline, that's very important.
I'm sorry, Senator, what's your question?
Be quick.
Thank you. The city of Charlottesville has, what's the timeline on theirs for the retention?
7 days.
7 days. And do you feel like that is adequate for your needs in getting the information that you need to make your city streets safer?
So part of our process was to get input from the community. It was about a 12-month process. And the community that I serve, that's what they expected of our policy, so that's what we have.
And is that working well?
For us, it is, yes.
Thank you.
Would you
Mr.
like
Chairman?
more?
It's like you don't know what you don't know, Senator. You know,
Mr.
I'm sure if you asked the chief that had 30 days, they could probably tell you story after story how that's been helpful for them.
Okay,
so.
Perry, you got a question?
I just want to comment on it. One of the hardest cases I ever prosecuted was a woman who went missing. And she was a vulnerable person, and she was murdered. She was pregnant, and she was murdered. But no one knew she was missing for about 2 weeks. Because she was vulnerable, because she didn't have community contacts, because the person who murdered her certainly did not report that he had then taken her body and disposed of it. And so there was no one looking for her. There was no law enforcement looking for her. And by the time her family realized, hey, we haven't heard from her in a while, 2 weeks had already passed, and that information would all be gone. And it took us, I don't know, that happened in 2011, and that individual was prosecuted in, finally, I think, 2022. That long to be able to accumulate enough evidence to be able to convict that person of her murder. And I do think that if we had had those license plate readers, those types of things, certainly for 30 days, it would have been a case that would have been much easier for us to attempt to prosecute.
And to your point, as I speak to my peers, I hear similar stories.
Okay, we got a lot of people who want to talk on this. We're done with the people in the queue. And we're going to limit it. Why don't we go 5 and 5? This is a big one. A lot of people want to talk.
So, yes, I have.
If you're in the virtual world and would like to speak to this bill in favor, please raise your hand now electronically.
Everybody get in line, queue up, get close to the mic. Go, go, go.
Good morning, Mr. Chair. Nathan Green, Commonwealth Attorney for the City of Williamsburg, James City County, here speaking on behalf of Virginia Association of Commonwealth Attorneys. We are in support. How this has been used in my jurisdiction. We had a situation where an individual, a mom was driving her kids to a band competition, and unfortunately, they pulled out in front of a reckless driver. That reckless driver got upset and at the next stop sign pulled out his gun and shot 5 times into the car, wounding both the child, and shooting the mother in the face. The community gathered together to provide life-saving efforts to save the mother and the child, but they weren't able to do anything other than identify the make or the type of car and the color. There was a license plate reader on the road earlier up, so the police were able to that day go back and look at and find the vehicle that matched that description. It then traveled in an area where there were no license plate readers. But luckily, it then went on to the Surrey Ferry, where there is a license plate reader. And they were able to find that vehicle again, and before the vehicle left the Surrey Ferry, that individual was found with the gun in his lap.
Hey, come on up. Sheriff's.
Mr. Chairman and members of the committee, I'm John Jones, representing the Virginia Sheriff's Association. We've been working with the Crime Commission over the past year, going back and forth. We've got this bill where it creates guardrails. Right now, there are none. We're using LPRs all over the state regularly, and we're solving a lot of crime. It's a tremendous tool that we have, and I've got 3 sheriffs here that'll be up in a minute to give you some specific examples of how it has increased public safety in Virginia.
Okay. Next up.
Chairman, just real quick, like I said earlier, the process we used took about 12 months, a lot of community input about this. And what I heard consistently, especially from our communities that are disproportionately affected by violent crime, is that they want this technology. They also told me that they want guardrails, reasonable guardrails. Right now, there are none. And so this bill, I think, strikes the right balance. Thank you.
Okay. Next up.
Thank you, Mr. Chair. I'm Kate Hanger. I'm the Executive Director of the Virginia Victim Assistance Network. We are a statewide organization representing the needs of victims of crime in Virginia. We support this bill as it ensures the technology can still be used for cases of domestic violence crimes, specifically in stalking and protective order violations. Thank you.
Good morning. Thank you for the opportunity. I'm Darrell Warren, a sheriff in Gloucester County. Quick story, in June of last year in Northampton County on the Eastern Shore, they had a drive-by shooting where several shots were fired by individuals in two separate vehicles. Single vehicle with 3 occupants fired several shots into a crowd of bystanders. A female teenager was injured in the leg. Second vehicle pursued that in retaliation, and several additional shots were fired. And during this exchange, bullets entered a single-family residence with small children inside. Within minutes of the shooting, deputies were able to identify the vehicles involved, resulting in capturing 5 individuals, recovering 3 handguns, a shotgun, and assault rifle. Thank you.
Morning, ladies and gentlemen. My name is Josh Marsh. I'm a lieutenant with the Accomack County Sheriff's Office's Criminal Investigations Division. I represent one of the rural areas that struggles with the right-of-ways. We primarily all our cameras are in condensed areas where we received a elevated crime during the COVID 2020 and 2021. Accomack County increased violent crime by 276%. So we implemented these cameras. We have seen a drastic drop in crime. We've been able to utilize those cameras to make arrests effectively in 23 shootings since 2022, 3 homicides, missing individuals, multiple individuals with active warrants through NCIC and VSIN that will send alerts that are associated to vehicles. Most recently, we had an individual that was working on his vehicle. He was approached by a male who displayed a knife, was forcefully removed from his vehicle, and his vehicle was taken. A stolen vehicle report was taken on that and was entered to NCIC. The vehicle, within an hour, started hitting on cameras and notifying Dover, Delaware police that our vehicle was in their area. Through contact of our investigators, they found the vehicle at a hotel, were able to obtain surveillance footage and identify the individual who stole that vehicle. Within 24 hours, the vehicle and that individual were under arrest in a different state. Thank you.
Okay, we got 3 seconds left. So who you are and you support.
Sheriff Rob Alderson, King Queen County Sheriff's Office. I want to talk real quick about the
Time's expired.
right-of-ways.
We got to move, man.
Okay,
So
the right-of-ways. In urban areas, they're very little.
we got
in
we
rural
got
areas.
We're out of time. We got to move. Just say who you are, who you're with, that you support the bill. I'm sorry, we ran out of time. We got to move.
Lieutenant Eric Hutton, Chesapeake County Police Department, support the bill.
Thank you. Anybody else? Oh, online. Just say who you are, who you're with, and you support the bill.
Patrick McKenna, you may now speak.
McKenna, Virginia Coalition Against Human Trafficking, we support.
Who are you with?
Virginia Coalition Against Human Trafficking.
Got it. Thank you. That's it. Okay. Let's reset the timer. Go to opponents.
48.
Attendees
Come on
online in
up.
opposition, please raise your hand and turn your camera on.
Come on.
If you oppose the bill, please come to the podium.
Chairman, Senators, my name is Michael Swaifer. I'm here today on behalf of the Institute for Justice, a Virginia nonprofit that litigates civil rights cases nationwide. I'm counsel in a federal lawsuit challenging the city of Norfolk's use of nearly 200 license plate readers to track the movements of drivers for 30 days at a time. The Supreme Court has made clear that this type of persistent warrantless surveillance of people's movements violates the Fourth Amendment. Where people go can be incredibly revealing. Our movements reflect our personal relationships, habits, and even our political beliefs, especially if someone is watching for as long as 30 days. That's the type of surveillance that's happening in Norfolk today, and unfortunately, HB 2724 does too little to curb it. It lets Norfolk continue to operate an extensive dragnet surveillance system of cameras that make month-long recordings of people's movements. It lets Norfolk continue to make that database available to any officer, and it lets Norfolk continue to give unknown officers outside of the community access to an unprecedented database of people's movements. Virginians have a Fourth Amendment right to be secure in their persons and effects against unreasonable searches. Dragnet surveillance, like what's going on in Norfolk, undermines that right, and demands legislative action. I urge the committee to oppose HB 2724 in its current form. Thank you.
Next.
My name is Julie O'Brien. I'm with Marijuana Justice. I'll keep it short. This is a mass surveillance bill, and we oppose the expansion of license plate readers onto 60,000 miles of highway. Thank you.
Thanks. Sarmiento.
Morning, my name is Monica Sarmiento. I'm the Executive Director for the Virginia Coalition for Immigrant Rights, a coalition of 50 organizations. Our organization is deeply concerned how this bill impacts new American communities. Right now, new American communities feel terrorized by the federal government. And we are seeing folks too afraid to go ahead and take their kids to school, to go to work, and constantly feel attacked. During such a hostile time for our community, we implore you not to allow these devices to store a full month of historical tracking data on every person on our roads. We believe it is important and necessary to regulate these devices and are grateful that this bill seeks to regulate what is already happening, but feel strongly that we should not be expanding where these cameras can go, and the retention period should be limited to less than 30 days.
Thank you. 2.5 minutes left. Go ahead.
I'm Lisa Polgar, activist with the Latino community in Prince William County, your former constituent.
Yep.
I have a serious concern about HB 2724 and its potential impact, not just on our immigrant community, but on all residents of Virginia. While the goal may be to enhance safety, the unintended consequences could be devastating and ripe for abuse. In this climate of heightened targeting of immigrant communities and the indiscriminate detainment of non-criminal immigrants, there is a real fear that this technology could be exploited by the federal government to enforce immigration laws through subpoenas. We request reduced data retention from 30 to 7 days and limit access to state or local authorities only.
Good to see you. Next up.
Good morning. I'm Carmen Rodriguez. I'm an activist in the Latino community in Prince William County, a member of the Indivisible Nova West and a Vizier affiliate. And I am deeply concerned about the potential impact of Bill 2724 on immigrant communities and human rights. We cannot afford to pass this bill without crucial amendments. Number one, reducing the length of time data is retained to 7 days and preventing its expansion to state highways. This is a call to action, and we urge you to protect the rights of immigrants, women, and all individuals who deserve to live with dignity and freedom. Thank you.
Thank you. Good morning. My name is Lenka Mendoza. I am with Dreamers Mothers in Action and National Domestic Workers Alliance, ISBACIR member. I am deeply concerned about this bill impact at our communities feel attacked. People are afraid to take their kids to school, go to the church, or even work. With yours, not alone this device to store month and tracking data. Will regulation is needed retention should be under 30 days, and expansion should be limited. Thank you.
All right, got 36 seconds left.
Valerie Slater, Virginia State Conference in AACP. We are opposed because of the expansion and because the time for retention should be no more than 7 days.
Good morning, Gabriela Watson with the Latina Institute of Virginia. For all the reasons previously stated, we oppose this bill as well.
Okay.
Mr. Chair, members, Chris Kaiser, ACLU of Virginia. We do want to see regulations of these devices, but we share our immigrant friends' concerns about long-term retention of system data. Thank you.
Okay, 4 seconds.
Rob Bogenclass, Justice for Virginia. We oppose the bill in its current form, and we hope the committee will amend it. Thank you.
Thanks.
Abby Phillips, Legal Aid Justice Center. We think this is a much better bill, but still have concerns about retention and expansion onto state right-of-ways. Thank you.
Thanks. Okay, online, 3 people, you need to say who you are, who you're with, and that you oppose the bill. We don't have time for more testimony.
Kalia Harris, you may now speak.
Hey, good morning. My name is Kalia Harris with Virginia Student Power Network, and we strongly oppose this bill. Thank you.
Beatrice Amberman, you may now speak. Beatrice Amberman, you need to unmute your mic.
Oh, thank you. Yes, Beatrice Amberman with the Virginia Coalition of Latino Organizations. And our organization opposes this bill unless it is amended, as previously stated. Thank you.
Guthrie, you may now speak.
Hi, I'm Levada Guthrie. I'm from Southwest Virginia. I'm a constituent of Senator Stanley and a private citizen. I'm very concerned about the bill in its current form and amended form, and strongly opposed to this bill. Thank you.
Okay, that's it for testimony, right?
Yes.
Okay, I have 3 people in the 4 in the queue, 3 in the queue to speak. I think everybody kind of knows that they're going to vote, and we're going to debate this on the floor, I'm sure. So if people want to talk, we'll talk, but we've run out of time here, so.
Mr. Chair.
Boysko.
Mr. Chair, I would offer an amendment to move it to 7 days for retention.
Okay. Boysko wants to amend something that was heavily negotiated, worked out in the Crown Commission, and created a very delicate balance, which will blow the whole thing up, but let's debate it. Okay, any further discussion about that? How do you feel about that, Madam?
Well, of course, I think that, I like the way it is, but I just want to make sure, because the bill says allows agencies to keep it up to 30. So 7 now, you're saying just only up to 7.
Yep.
All right. So, of course, Mr. Chair, I have concerns because you're taking away an ability to, but it's the will of the committee. But the shooters that I gave it examples of a missing child for a missing 4-year-old, if it wasn't for the 30-day retention, would not have been found.
Mr. Chair.
But it's the will of the committee.
Mr. Chairman.
Okay, hold on. Benjamin, you have something legal feedback on that?
It is.
Okay.
I would point out that retention is also important to the criminal defense function, so that the information is available for that function.
Right, so in some ways, you might hurt a defendant's ability to defend themselves because the data's gone. Okay. Any other debate on this point? I think Jordan, I heard it made a noise. You still want to talk?
Mr. Chair,
Okay, there was some seconds down there. Yeah, there were seconds. Yeah. So Herring, you had something else?
Yeah. Just the only other concern I have, Mr. Chair, is that when we talk about interfacing with the Community Policing Act, so we can get data and get reports, I do not know how that will affect it. So I do not know, but could affect that as well.
Okay. Any other discussion about the 7 versus 30? Okay, so the motion is to amend it from a 30-day retention period to 7. All those in favor say aye. Aye. Anybody opposed? No. Okay, do we need to record that? I think the noes have it. Anybody want to record it? Doesn't look like. Okay, noes have it. All right. I still have Boysko. You have more you want to say, or? Okay, Favola's in the queue, and then Aird and Carol Foy.
Thank you, Mr. Chairman. I would like some illumination on why you use such a comprehensive definition of law enforcement agency. Why did you use such a comprehensive definition? I would considerably like it narrowed.
Well, to limit it, Senator, honestly, Mr. Chair, Senator, is to limit it so that we are only talking about state police, local law enforcement agencies, or local police, or local sheriffs. So basically, we're excluding federal. That's why. So.
Senator Favola, you have another question?
Yeah, Mr. Chairman, I mean, you're picking up campus security, you're picking up ABC enforcement officials, you're picking up a range of other individuals under your definition, not just state and local.
Mr. Chair, Senator, I would say that's a fair point, but I would also say that's the exact reason. We want to make sure when they're placing these cameras, which they could be today, and we have nothing. This will incorporate them and not exclude them from the requirements in this bill.
Okay, now I got Aird.
Mr. Chair, speaking to the bill.
Go ahead.
I think it's important to go on record to say that we had a whole line of individuals that stood up in support of the bill to talk about how great of a tool that this has been and how it has helped solve intense crime in condensed areas and murders and robberies and missing, exploited individuals, and that's fantastic. Like, I want to thank law enforcement for being able to use this tool, which sounds to me that where it's currently located has been highly successful in supporting the work that they have to do on a day-to-day basis. I think that I want to place emphasis on expanding these into right-of-ways. I think I heard the patron say that, and I think I heard law enforcement say that largely these are in some ways already being used in right-of-ways, which is why we need these guardrails in place. I think we are doing real harm by expanding this without allowing additional time to see exactly how these guardrails will work, how they will be applied consistently throughout the Commonwealth. And I do not think that limiting the legislation to the existing cameras that are in place will be a detriment to law enforcement in any way. We are not standing here on this day as saying that we want to take the cameras away. We are in agreement that the cameras are a tool and they are helpful. But what I would say and would further emphasize is that this is not the right time to expand them further. We need to see how this legislation will work with the cameras that are in place.
Okay, I got Carol Foy, then Stewart.
Thank you, Mr. Chairman. Speaking to the bill.
Go ahead.
The narrative about the ALPRs is singly focused on stationary ALPRs for law enforcement to use for investigative purposes. However, according to the Virginia Crime Commission, ALPRs can be used by homeowner associations and government agencies for vehicle repossession, insurance investigations, business operations, and it's not just fixed ALPRs with this bill. There will also be more mobile automated license plate readers that can be mounted on dozens, if not hundreds of cars, tracking your movements. And as was stated, that these are already pretty much being used, abutted or adjacent to our highways. And if that's the case, then why is this bill needed except for the guardrails? And so I just don't think that the expansion is the appropriate time right now. And I would add to Senator Ayer's concerns that there needs to be more information about the ALPRs in current use before we expand it. Also, when ALPRs captures a photo or video of my vehicle with the location, date, and time, and stores real-time and historical data, I don't see the difference between an ALPR and a car tracking device. And we know, because we're familiar with car tracking devices, that you have to have a search warrant because it is an invasion of your privacy to be able to track every single place you have gone, the route, the time, the location of your vehicle. And it's not the same as having, the machine track when you go through the HOV lanes, because I go through and you don't know where I went. These ALPRs will track you. If it's on a vehicle, it can actually follow you where you're going, anytime, anywhere, any day. And that is problematic. There has been erroneous plate reads and misuse of the ALPR systems. And the Virginia Crime Commission noted that ALPR can lead to disparate impacts on minority communities. And I think that is something that we are not seriously considering, because we all know that these ALPRs won't be deployed in gated and country club communities. They will be concentrated in Black and brown communities, the exact communities that complain today about over-policing. There's nothing to stop ICE from getting a subpoena or search warrant to target immigrants. There's nothing to stop another state that has criminalized abortion care subpoena to track the movements of their residents coming to Virginia to get abortion care. We have the third largest state-maintained highway system in the nation. We are authorizing mass surveillance on a massive scale. This bill will authorize 60,000 miles of highway, which today these companies cannot use. I do believe that ALPRs are a useful tool. I appreciate the guardrails that the patron has placed in this bill. I believe we should pass the guardrails, come back in 2 years after studies have been done, and we see how the systems are working. This is big government, big brother, in a big way. This is government intrusion and monitoring the actions of its citizen in an unprecedented manner, and this bill will authorize it. If you believe in small government, this isn't your bill. And so many of us agree with and want law enforcement to use automated license plate readers as a tool with guardrails. I can support that, but I cannot support the bill as written with the 30 days and with the 60,000 miles of highway expansion.
Okay, Senator Stewart, last one in the queue.
Mr. Chairman, thank you. Mr. Chairman, I don't know that I disagree with the thing that Jennifer Carroll Foy just said, but the problem is this ship has long since sailed. We got cameras on us in here. We got cameras on us when we walk outside. We got cameras on us when we walk into the garage. We got cameras on us when we drive outside of the garage. We got cameras on us when we drive out of the city of Richmond and right on as far as we're going. This ship has long since sailed, and I think what Delegate Herring is trying to do in the Crime Commission is put some reasonable safeguards in this. You talk about public right-of-ways versus private right-of-ways. They're already all over the private right-of-ways, and we don't know where they are. In this bill, at least Delegate Herring said we're going to know where they are on the public right-of-ways, and you all forget something. This is also information that you can gather to help defend people, to prove that people were not in an area where they were alleged to have been. So it really works both ways. It helps. It helps. It can help us catch criminals. It can help us prove people are innocent. And I thank the Crime Commission for their work. I thank Delegate Herring. I know this was a really tough bill. I'm going to move to report the bill.
Yeah, Senator, I had a client who was accused of stealing a truck from Home Depot, and we were able to reverse engineer. He wasn't there by using his cell phone data. I'll just note that the private sector has all kinds of data about where you are. They can track every single restaurant, eating, every retail establishment, every abortion clinic, every law firm you ever visited by looking at your cell phone data, and that data is available for purchase to the government and anybody else that wants it right now, unless I think Perry had a bill that prohibits that, and I think Favola had a bill that prohibits it on for reproductive health care this session, but we'll see what happens with those. But in any event, the data's out there, and it's been a lot of work put into this bill. A lot of work, it's probably an understatement.
It's been a lot of work.
So why don't we, there's been a motion and a second to report the bill, refer to finance. Clerk will open the roll.
Ayes 6, noes 9.
All right, bill fails to report.
All right.
All right.
Thank you, Mr.
More
Chair and
unregulated
committee.
surveillance.
Unlimited.
All right, next up, I've got, let's see, who do I got in the queue? Does Walker show up? Walker, you made it. Sexual extortion, let's see. Section added by Bell, 2300 for judicious and past tense. Okay, you want to make it so you can't have sexual extortion in regard to housing, is that right?
Ready to go?
Excuse me?
I say, am I ready?
Yeah.
Oh, okay, I apologize.
You want to make, you can't use sexual extortion for housing, right?
Yes, sir, that's
Landlords. Okay.
All right.
What did I miss?
So, this bill strengthens Virginia's sexual extortion laws by making it a Class 5 felon to use financial threats such as eviction, loss of housing, or property damage to force someone into engaging in sexual acts. The penalties contained in this bill align with existing Virginia law on sexual extortions and the code section. Like current law, the bill ensures that housing, property, financial threats are explicitly prohibited, closing a loophole that currently allows offenders to escape this prosecution. This is an issue that we're seeing in Central Virginia with a number of landlords forcing their tenants into certain sexual acts. This bill ensures that the housing and financial manipulation is recognizes as a form of sexual extortion, addressing real cases in Virginia where landlords exploit tenants without facing appropriate penalties. We're trying to send a message here. I have support as well from the Commonwealth Hanover. That's the bill before you, Senator, committee members. Trying to protect tenants.
Okay. Any questions for Delegate Walker? So, hold on. I have a question for council. Benjamin or Joanne Fry, Ms. Fry. So, suppose a landlord today says, I want you to do something sexual in exchange for, I'm not going to evict you, or, I'm not going to make an issue about this security deposit or something like that. That's not already like a false pretenses situation, or something that vitiates consent. I see Perry.
No, Mr. Chairman,
might have
I
an opinion,
don't
too.
think that the law prohibits obtaining an intimate act by this type of threat. It would have to be a threat of violence.
Okay. Looks like Fry concurs. Perry, you about to say something?
I'm sorry, Mr. Chairman, I'm not sure I understand the end of Mr. Benjamin's question, but I was quite frankly only partially
My question.
listening. I know, but the end of a statement about it would have to contain a threat of violence. I'm not sure about that. Obtaining by false pretenses, though, typically you have to have it. We used to have this problem. I know exactly what you're talking about. Yeah, especially in this context where it's not an exchange of monies, right? And so this is not an exchange of money. This is an exchange of sex.
Okay.
So no, I don't think obtaining by false pretenses is covered.
Okay, so this picks up new activity.
Yes.
Okay. All right. Anybody else have any questions for Delegate Walker? Work group is. Don't think there's any other questions. Okay. Is there anybody out there? I know there's probably a few people in support. Is there anybody opposed to the bill? Doesn't look like it.
Re-refer to finance.
Okay, it's been moved and seconded. We report the bill and refer it to finance. Clerk will open.
Good luck, Wendell.
Senator Gayer? Ayes 15, no zero.
Thank you, Mr. Chairman, committee members.
All right. Next up, I've got Scott. Is Delegate Scott here? Still not here. Next up, I've got. Huh? What? Yeah. Oh, we didn't take him out of the queue? Okay. God, he's gone. All right, Hernandez, 2351, suspension bonds. I think you got an amendment.
I have a substitute, Mr. Chair.
You have a sub or an amendment?
I believe it's a substitute.
Is it in our package?
Should be.
Oh, yeah, it is. Okay, Deeds moves, Boy Scout seconds, the sub. All those in favor say aye. Aye. Anybody opposed? No. Okay, I see the sub here.
And just speaking to the
Sets a
substitute,
limit
Mr. Chair.
at 200 million and has a cost of living increase.
Inflation adjustments automatically every 3
Okay,
years.
so
That's
instead of
right, Mr. Chair.
unlimited $200 million cap, instead of 25 million with a cost of living increase. Okay. Anything else you want to say about that besides that?
No, I think that's pretty straightforward on the substitute piece. I'm happy to speak to the bill more broadly.
It must be nice, yeah. That's it. Okay, any questions for the delegate?
Well, I'm happy to speak to the bill more broadly, Mr. Chair.
Yeah, go for it.
Just for some
Now's your
context for the committee and for the public. So when we're talking about appeal bonds, right, we're talking about the bond that a losing defendant must post to secure its right to appeal and stay the judgment. Typically, that is the bond, the judgment amount plus interest. And from a public policy perspective, right, the goal is to make sure that victims are fully compensated and also to root out frivolous appeals. I do want to be clear, even though we are increasing the cap, $25 million is, if you look at nationwide, quite on the low end of the spectrum relative to what other states do. But we are also keeping the discretion that exists in the law for courts and the parties to reduce the appeal bond amount. That's lines 102, paragraph L, like I said, current law. So the court already for good cause can waive anything in excess of the compensatory damages, so the actual damages. The parties separately, the second sentence of that paragraph, have authority to make a side deal, agree to something less. So overall, this is an attempt to modernize. You know, there are several states that have no cap at all. The federal court has no statutory cap. So this puts us, I think, more within the range of sort of what is sort of normal.
We basically the
nationwide.
lowest cap in the country, pretty much, right?
25 is one of the lowest in the nation. That's right.
Okay, all right. Any other questions for Delegate Hernandez? Okay, why don't we take the opponents first? Set it at 3 minutes. MJ, got that? Okay, come on up, you're opposed, 3 and 3.
Any attendees online opposed, please raise your hand and turn your camera on.
Good morning, Mr. Chairman. I'm Sherman Joyce, President of the American Tort Reform Association. I want to thank the delegate for advising us of the change from the original House bill. We were very concerned at the prospect of Virginia being the first state to completely abolish an enacted bond cap statute. I would say, however, that Virginia's record of preserving the opportunity for all civil litigants to bring an appeal is in jeopardy, even with this
increase with this new amount of the appeal bond. From a factual standpoint, Virginia is one of 15 states with a $25 million bond cap. 5 other states actually require no bond cap at all, or no bond, the posting of any kind of a bond in a civil case. And so with respect, we would disagree at the notion that Virginia was an outlier. We believe, in looking at the records that we have, a $200 million bond cap for all civil litigants would put Virginia at the very top end of the scale. We believe that if a change is needed, something more reasonable at a lower level would be appropriate. But at the very least, it should be understood that, number one, that a bond cap, or without a bond cap, many defendants may not have a meaningful opportunity to bring an appeal. Moreover, it also can be the case that a bond in that amount may not be attainable. It just may not be something that can be acquired, even if a defendant wants to bring a case. Preserving the right to appeal, we think, is important for all litigants. And I think enacting a reasonable reform along the lines of what's already on the books, and also enhanced by your more recent statute preserving the right of all civil litigants to bring a right of appeal as a right to the intermediate court is appropriate. My organization strongly believes that your current law is very much in line with the mainstream of the states around the country, and we would encourage maintaining that or something as close to it as is possible. Thank you.
Just so we're clear, there are several states that don't have any cap, probably like, I don't know, 5 or 10 or something, right?
There are 5 states that we know of that have none. So between those 5 states and the 15 with a $25 million cap, the reality is that 20 states are very much in the mainstream of American law. Thank you.
Got it. Thank you. Okay, next up, 24 seconds left.
Mr. Chairman, Brett Vassy, Virginia Manufacturers Association. We'll give you some perspective. We're looking at this from a competitive point of view. Virginia, North Carolina, South Carolina, Georgia all have 25 million. When companies look at locating in states where they have products, where they have product liability, they're going to look at this. Mr. Chairman, the other thing is just a practical reality. We have companies in the defense supply chain that were required to manufacture asbestos products for the Navy. They can't afford a $200 million bond that they'd have to put up. It could bankrupt these companies as they're trying to work through these liabilities. We appreciate the delegate, though, sharing the information with us. Thank you.
Okay, just remember, we have a punitive damage cap at $350,000, so it's kind of hard to get the big damage awards in Virginia without punitives. Go ahead.
Mr. Chair, Eleni Polis with the Virginia Chamber of Commerce, and we'll associate our comments with the previous speakers.
Thanks. Sorry, let's reset the timer. Anybody in support want to speak?
Any attendees online in support, please raise your hand and put your camera on.
Doesn't look good. Okay. Bill's before us, and Peek, I'm sorry, you were in the queue. I saw that. Yeah.
Question, and counsel or patron. The appeal bond, you can still proceed with the appeal. It's just the bond that prevents them from acting on the judgment, correct? So you can still go with the appeal, and then they run the risk, if they execute the judgment, of being reversed, having to repay. Thank you.
That's right. Okay. Any other questions? Okay, this bill needs to not go to finance. So, is there a motion? No finance. No finance. So Aird moves and Carol Foy seconds. The bill be reported. Go to the floor. What, Sabrina? Did I get? Yeah, the sub. Yeah, right. Okay. Clerk will open the roll.
Yeah.
Okay, bill reports.
Knows one.
Okay.
Thank you, Mr. Chair.
Bill reports. By the way, one other I forgot to take up was, I think, Senate Bill 1797. I didn't take that up. It's Helmer, right? Right? Okay, we need to take that up really quick. I told Helmer he didn't need to come. 1797 by Helmer, basically the concealed handgun reciprocity bill that we passed last year on a party line vote. The bill this year is identical to the bill from last year, except this year it accepts anybody who's active duty military who transfers here. So if you're active duty and you have a concealed carry permit from another state, you can use it in this state. Otherwise, It has to have the identical restrictions that Virginia has. It was a party line vote last time. So Boysko moves and Aird seconds. The report refer to finance. Clerk will open the roll. You guys are all no. No, you guys are all no.
Thank you, there, Scott.
Ayes 9, no 6.
Yeah, the bill's off to finance. Favola, you keep appearing in my queue. Do you want to say something in the? You're waiting to speak. Light is on.
It's just a default.
Okay. Next up, I got Munden King, 2362. Passed the House 94-2. Sale of real estate for delinquent taxes.
Thank you, Mr. Chair, members of the committee. This is a Boyd Graves bill that was crafted with input from the Virginia local government authorities, and it basically requires any person with an interest in a property to be named as a party defendant. It requires public notice of anticipated sale, and it's designed to make these transactions of property for unpaid real estate taxes easier and more transparent.
Mr. Benjamin, was there a question about line 72? No bill of review for decree entered pursuant to 58.13969. I have my work group notes say there was some question about that. Or Sabrina or somebody. The work group had a question about that.
No.
This was not my question, Mr. Chairman.
Okay. No? Nobody else has questions about it? Hold on, wait. Any opposition to the bill?
Report referred to finance.
Okay, maybe you guys can, if there's an issue, can you guys look at that and let me know what the issue was? Because I don't understand the question. Okay, it's been moved to second bill be referred to finance. Clerk will open the roll.
Thank you, Mr. Chair.
Yeah, and
members
delegate,
of-
just so you're
14,
clear.
no 0, abstentions 1.
Thank you, MJ. There was a question as to why there was no bill of review for a sale, for a decree entered pursuant to 58.13969. That was the question, delegate. Might pop up in later, so. Okay, sure you will. All right, next up, I got Cousins. Use of crime code and documents for jailable offenses, 2236. Waiting there a long time.
Breakfast and came back. Thank you, Mr. Chair,
I think there originally was a concern. It needed to go to
members of the
finance.
committee. This legislation simply clarifies that the Virginia Criminal Sentencing Commission has the authority to develop, maintain, and modify the Virginia crime codes as may be deemed necessary. This clarification is necessary to ensure that we have accurate and consistent statewide data on criminal offenses. And it also ensures that the Sentencing Commission can accurately complete its work to evaluate and implement sentencing guidelines that are used in courts throughout the Commonwealth.
So this is a sentencing commission recommendation?
Yes.
Okay. All right. Okay, any opposition? It moved and seconded, the bill be reported. Clerk open roll.
How are these different than visa?
These are the codes for the sentencing guidelines, I think. Yeah, the VCC codes for sentencing guidelines. Yeah.
So do they not have that authority now?
They,
So where did they get originally created?
Okay, why don't you strike the roll?
Someone
Okay,
from
hold
the
on.
Sentencing Commission.
Perry's on the commission. Why don't you
Okay,
explain what happened? Oh, she is?
Yes, I
Okay,
am.
well, go ahead. Sorry, go ahead.
So the Virginia Sentencing Commission, as Senator Perry mentioned, believes that there needs to be more clarification essentially in the code that clearly gives them the authority, the sole authority to implement these VCCs, the Virginia crime codes.
McDougal, you happy?
Yeah, Mr. Chairman, so are these prospective going forward? I guess what I'm concerned about is somebody committed and comes into using the guidelines. How are you treating a robbery that happened 25 years ago with a gun? Are you going to go back and rechange that code so they fall into a different category?
Mr. Chairman.
Go ahead, Perry.
Yeah, no, they don't. And this doesn't really have anything to do with that for what it's worth. They just want to make sure that they can use it. I love the VCC codes. I think they're very, very helpful. And that exactly their purpose is that we can tie into exactly what the law was at the time. And the VCC codes help us do that if they're accurate, in the best way accurate. Sentencing Commission just wanted to make sure that they continued to have the authority of those VCC codes, basically that they belong to them. They are the originators of them. They're the creators of them, and that other people couldn't hijack them and use them maybe for their own purposes. So it doesn't change anything for what the VCC code was prior to whenever y'all changed the robbery law 2020 or whatever. That VCC code for robbery would stay the same. New VCC codes have been introduced as it relates to the tiering out of the robbery system now. But it essentially, Delegate Cousins can correct me if I'm wrong. I don't have it up in front of me right now, but I do remember the discussion on this in the Sentencing Commission. It just makes it where VCC, or the Sentencing Commission, continues to be the arbiter of the VCC codes, what they are, and making sure that they contain that they control those deciding that information.
Yeah, that's correct.
Okay, there was a motion. Motion to report the bill. Clerk will reopen the roll. Ms. Stanley?
Oh, sorry. His vote is.
Yeah, he's stuck with
proxies.
Peak right now and proxies.
Ayes
so-
13, no 0, abstentions 1.
Yep, okay. You're out of here. Jones, 1661, you want to limit installment payments to 25 a month unless the defendant agrees otherwise. Right?
Yes, sir.
Anything else you want to say about that? I think there might be some concerns about it, so you might want to say some stuff.
Yes, sir. Mr. Chair, members of the committee. Simply 1661 seeks to update Virginia law to offer more flexible payment options for fines and costs. It allows deferred, modified, or installment payments and exempts Social Security recipients from payments. The bill ensures courts offer payment agreements based on a defendant's financial ability. It sets a minimum payment of $25 per month with adjustments possible. And again, those recipients of Social Security are exempt from those payments. Just seeks to deal with and address financial hardships and takes each individual by party basis.
So this is limits the installment payments to 25 a month, whether it's a misdemeanor or a felony?
Correct.
Mr. Chair.
Okay, Senator Deeds.
Could you point me to the language that says that this $25 payment's applicable for people that are indigent?
I don't think it says that.
I don't think it says that either. I think
It's
it's
just up to the court.
up to a court.
Well, but this puts it up to the defendant, actually. Because it says it's 25 a month unless the defendant agrees otherwise. The court doesn't even have discretion about it. All right.
Mr. Chairman?
Yeah,
A
Senator Carol Foy.
Question for the patron. I believe I read or saw somewhere that this is something that the DMV does. Is that correct?
Who?
The DMV, they have like the payment plans of $25. Is that right? Similar?
I'm not sure what the DMV does. I don't know if this addresses that, but just focuses on individual coming back, returning citizens, and their particular fees that they owe.
Yeah, I think the.
Go for it.
Thank you, Mr. Chairman. I think the information that was shared is that there are other government agencies that do permit payment plans and installments as low as $25 per month.
Okay.
Mr. Chair.
Deeds.
Doesn't this say the maximum is $25 unless the defendant agrees to pay more?
Yep, that's what it says.
Mr. Chairman, yes, I believe that that's what it says. But if a person can
Okay,
afford
Carol.
more, the likelihood that they'll pay more.
But
is
does
that-
it say
Deeds.
that, doesn't it say that he's the one that chooses that? The court doesn't decide.
Carol Foy.
Yes, I believe that if a person knows how much monthly income they have coming in and they can't afford much of anything else, or they want to make sure they're not delinquent on their payments, and if they can pay more, they will, but they don't want to be found in violation, so they'll pay $25 per month. But I don't think there's anything in here preventing them from paying more.
Okay, any other questions to the patron? Okay, why don't we set the timer at 2 and 2? People in support, come on up.
Attendees online in support, please raise your hand and put your camera on.
Madam Chair, members of the committee, Sean Winetta, speaking on my own behalf here, and I'll just use my own scenario for why this is a necessary bill. When I came home from prison after 16 years, I had multiple jurisdictions that I owed money to, Fairfax and Arlington, neighboring jurisdictions. When I went to start making my payments to Fairfax, they said you could enter into a restitution agreement, payment agreement of $30. So I entered in that. I've been paying more on that. However, when I went to Arlington, they said that I had to pay 5% of what I owed. I had an embezzlement charge. 5% of what I owed in Arlington was $3,850 per month that I had to pay. And otherwise, I had to get an order from the court, retain an attorney, all those different things to get that reduced down to something that was reasonable that I could actually afford to pay. So that's why this universal minimum payment is necessary. And Mr. Chair, Senator Carol Floyd, $25 is what DMV does use. Yes. Thank you.
Okay, next. We got 1 minute.
Mr. Chair, Committee, Fatima Moahed with the Humanization Project. Currently, it's much harder to pay the minimum payments needed to adhere to probation for the same conviction in some jurisdictions than others. Yes, DMV does do a $25 minimum payment. This is just a good sense bill, and it helps people with their returning citizens. We hope you support the bill. Thank you.
Hello, Chairman, members of the committee, Maisie Osteen with the Legal Aid Justice Center. We work with a lot of people trying to pay their court debt, and we find that folks, if they have something that they can consistently pay, they want to pay this off. There's real incentive to be done paying, and this allows the process of collections and interest to not accrue, so somebody can consistently make those payments and start making some real headway into their debt. That's the reason that we support this bill. Thank you.
15 seconds.
Mr. Chair, members of the committee, my name is Cammie Blatt with the Commonwealth Institute, and we support this bill.
Justice for Virginia, we support the bill.
Thank you for being quick.
Dominic Martin, New Virginia Majority, and we support the bill.
Sorry, one online, say who you are and that you support the bill, who you're with.
You may now speak.
Good morning, Sheba Williams with No Left Turns and Pretrial Justice Coalition. We support the bill. Thank you.
Thank you for being brief. Okay, let's reset the timer. Anybody opposed?
Please raise your hand and put your camera on.
Oh, yes. Nobody cares about the judges losing all their discretion. Okay. It's been moved and seconded. The bill be reported and referred to finance. Clerk will open the roll.
Ayes 8, no 7.
All right, you're off to finance.
Thank you.
Wait, he has one more.
Oh, he does?
Yes, sir, I do.
1665.
Itemized statement on fees and stuff. Passed 21 to 1 or 88 to 7 out of the House. 1665.
Yes, sir, Mr. Chairman. This was a piece of legislation I brought last year. It was vetoed by the governor simply because of a $10 of fee that they wanted to assess. What this bill simply seeks to do is to allow individuals to receive an itemized statement of court-ordered financial obligations at assessment and upon request. It's not something that's going to be misused. The person's not going to go in there and ask 15 different times what they're getting billed for, but something that we can get at Applebee's or something that we can get from a court.
We passed this last year and it got vetoed by the governor,
yes, sir.
right?
Yes, sir.
Okay.
Refer to finance.
It's been moved and seconded. The bill be reported and referred to finance. Clerk will open the roll.
Thank you.
Ayes 9, no 6.
Okay, bill reports off to finance. Next up, I got Henson. Henson, you've got a bill we heard last year.
Yep.
I think also got vetoed by the governor. How's
Yep.
it different from last year?
We made it slimmer. So this bill takes out subsection B that would have allowed for petty larceny, grand larceny, or violent crime. So we just reduced it to only dealing with marijuana convictions.
Okay, but still, people who don't like it probably still aren't going to like it, probably.
Well, bipartisan, majority and minority leader both supported it.
Okay. Okay, anybody got any questions for this bill?
I'll move report and refer to finance.
It's been moved and seconded. We refer this bill to finance. We heard last year. Clerk will open the roll.
Ayes 9, no 6.
All right, next up, we got Price, who has been diligently waiting for a long time. Patiently. Yep, patiently. Price, what's your last one you got with us? Violence Intervention Prevention Center.
Yes, so Mr. Chair and members, if you were here in 2022, you saw a version of this from Senator McClellan. The major changes are that it would be in conjunction with the Department of Health, Department of Social Services, Department of HDS, Department of Education, and Department of Veteran Services, and realizing that it's both a public safety and health issue. And the other change from 2022 is now with the I guess, the mandate that the CDC not do anything, and also the White House Office of Gun Violence Prevention being shut down, that the federal information that we once had is no longer available. So Virginia needs to take care of itself.
Mr. Chair.
Yeah.
I move to report and refer to finance.
Okay, Deeds moves and Aaron Boyska second. Bill be referred to finance. Looks like McClellan's escaped the Senate 24-16.
It's close enough to what she would want to see.
Yeah, and so we're going back to finance. Any other questions? No? Okay, clerk will open the roll.
Ayes 9, no 6.
Okay.
Thank you.
All right. Now we're getting to some fun stuff again. Delegate Simon. Everybody's email boxes have blown up in the last 24 hours because of your bill.
Mr. Chairman, let me go ahead and actually address that if that's all right, okay? So I want to be really clear because I got the email too. And so this bill does not do what the email says it does. I just want to be clear. If you guys look at the bill under existing law, right? This is not the highlighted portion. This is the existing law. It says it shall be unlawful for a person or persons with the intent of intimidating another person or group of persons to place or cause to be placed a swastika on any church, synagogue, or other place of worship, right? The email you got says my bill makes it criminal to place a swastika, an Indian swastika, which goes the other direction, is perfectly normal holy system on their temples. That's
Okay,
just
hold on
not,
a sec. Slow down.
That's just not true.
Slow
My
down.
bill doesn't-
Hold on. Slow down. Wait a minute.
Yep.
Just so we're clear, the Indian swastika goes a different direction, or the Hindu swastika goes a different direction than the German Nazi swastika.
That is correct.
Okay.
Okay?
Just-
And
I
nothing.
want to make sure we're clear about
again,
that.
under current law, what they're concerned about, it's already existing law, but also clearly they're not doing it with the intent to intimidate another person or group of persons, right? All this bill does is expand the places it's unlawful to try and intimidate someone with a swastika to their private property without their permission. So under current law, it's a crime, it's a felony to put a swastika on my Jewish community center. If you come and burn it into my front lawn, or you come and put it on my front door on my private property, it's not a crime. And so what I'm trying to do is just true these things up. Now, I am not at all unsympathetic to what the folks that are emailing are concerned about. And I certainly get it. And I'd be very upset if my holy symbol has been equated with this awful symbol of hate, and I get that. Unfortunately, I don't know that we can address that by rejecting this. Well, certainly if we rejected this bill, that wouldn't change. If this bill died, we'd still have the current law, which would still have the problem that they have. The other concern I've got is if we do it, one of the things they've asked, which is to stop using the word swastika and start using the word Hakenkreuz or some other crooked cross word. One, people don't know what that means. Two, you get a clever Nazi who says, well, I'll just paint it on Marcus's front door backwards. And now I'm not breaking the law. But it's going to have the same impact on the person they're trying to intimidate, harass, or whatever. if they see it backwards. So I don't see a quick and easy solution. I do think, again, this is with the intent of intimidating another person. It's got to be very specific intent, so I get why this has raised a flag in that community. I just don't think that this bill does what they think it does. And I'm happy to answer any questions.
Okay, I got Salim, and then Stewart, and then Boysko. And we got 15 minutes before caucus and 5 bills left. Salim, get quick.
Thank you, Mr. Chair. I'll make it quick. To Delegate Simon, I do appreciate you clarifying. That was my question, is some of the folks had concerns that some of their religious schools do have these symbols that are either painted or that are put up. And I don't know if this is for council, are we able to differentiate, or at least in some sense put the word Nazi in before swastika to indicate that when we're talking about swastika in this case, that is exactly what we're talking about? Because my understanding is currently we don't define what a swastika or a Nazi swastika is.
I don't think there is anything as a Nazi swastika.
Hey, council, you got to answer that?
Mr. Chairman, I'm informed swastika is not defined in the code. It would have its commonplace meaning. As to the question directly asked, of course, we could insert any word if necessary.
Mr. Chair.
Yeah, Deeds.
Aren't we still dealing with the language on 17 with the intent of intimidating another person? We place it with the intent of intimidating whatever it is?
Yes.
Mr. Chairman.
Yeah, McDougal.
Mr. Chairman, but in section D, it says, for purposes of this section, the placing of that shall be prima facie evidence of the intent. So if it's there, it is prima facie. So if you put your religious symbol on another person's property without their prior approval, then I think you're in violation.
Mr. Chair.
Mr. Chair.
Hold on. I got Simon wants to respond.
So real quick, I think that Senator McDougal just omitted an important word, which is such, right? So it's not any placing of a swastika is going to be prima facie evidence, any such place. Again, it references back to the language above with the intent. So I get what your concern is, and again, and I'd be open if there was a way to fix just the D part, to say if a Nazi swastika for would be prima facie evidence. Again, I'm a little concerned that people are going to game that, right? And again, just turn it around and still have their intimidating, harassing effect, but say technically it's not, or alter it just a little bit and say now it doesn't count. I don't want to open that up for. I think the intent is more important than the specifics of what the shape is.
Perry.
Yeah, I apologize. I wasn't here for the beginning of the conversation, so I was trying to watch it on the screen in the back. Delegate Simon.
But are you on this?
I'm sorry?
Are you on this question, colloquy?
Well, I have a more general question about the word swastika in the bill generally. So I think which I think is problematic to the entire bill, because if you're a prosecutor and you go to prove this, like my understanding is that the hate symbol that was used by the Nazis is not called a swastika at all. And so if I'm the prosecutor and I'm required to prove that this symbol that someone put on someone's door did, something hateful with, that it is a swastika, but it's not a swastika that they use. So I don't know how I would go about proving that. I think you used the word a while ago, and I'm not going to try to pronounce what it actually is.
Hakenkreuz.
Thank you. Yes, that is actually the hateful symbol used by the Nazis. And so I'm just concerned, as a general matter throughout the bill, if we use the word swastika over and over again, we're referencing something that is actually not what it's called. And as a prosecutor, I would be required to prove that it was a swastika, when in fact it is not, in fact, a swastika at all. Does that make sense?
Okay.
To people on the dais?
Comment, but I keep ignoring Stewart, who's been in the queue for a while.
Thank you, Mr. Chairman. I've been waiting patiently, and actually that's what I was going to highlight. You found a problem with the original language in the bill, and a solution may be to define somehow swastika that you intend to
right. I think
prohibit
the patron's concern about that, though, is they'll start using the reverse swastika for the same purpose, and then they won't be able to use it. So, right, Simon, is that your concern?
So my concern is that if you want to put a very narrow definition of what a swastika is, that people will achieve the same intent by switching it around. And I look, this is the existing language in the code. And again, I know that sometimes people find an old code section and figure this is a good opportunity to get their hooks in it and fix it and do something different with it. But I just want to be clear, this is the language we've always used. Whether it's ever been prosecuted successfully or not, I can't answer that.
Perry, and then by Boysko in the queue too.
Mr. Chairman, I think that we could, I think it has been used successfully. I think we had it in Loudoun County used successfully in a juvenile case, and they were required to do some reading essays and things like that on it. But I do think we could probably, if you want to use the word swastika, because that's, I think, how a lot of us refer to it, and it's known commonly, I think you could probably say, use some other language that ties it into the other word that I can't pronounce. And as well as, whether it is inverted, flipped on its back or whatever, right? And I think with your other language, like with the intent to harass, I think that goes a long ways towards trying to get towards what the patron's working on, again, which I am very sympathetic to.
Right. I think that council has a suggestion for language, but I think what Senator Perry suggested is that we define it, but also say, or like symbol with the intent, so that we can get to your point.
Yes.
So it sounds to me like this needs some surgery. And we're not gonna be able to do it in the next 8 minutes with like 5 more bills up or whatever we have left. So why don't we make an amendment to it? And it sounds like at this point, we have no choice but to either figure it out before it goes to finance or do it in conference.
Okay.
Huh? Okay, so in the meantime, why don't we amend, suggest by council to start this amendment process so we can get this in conference, is to, council, where do you want to add this?
Mr. Chairman, it occurs to me that if we simply substituted the word symbol for swastika, because it's paired with the intent to intimidate and other elements, that might suffice for everyone's purposes.
Yeah, probably some First Amendment, I don't know, ambiguity in there.
Mr.
Ambiguity
Chairman,
about symbols.
I don't think there'd be a First Amendment concern if it's with the intent to intimidate.
But any symbol?
Correct.
Mr. Chair, Mr. Chair. Mr. Chair.
Well, we need to move this conversation along.
We have a
Mr. Chair.
reenactment clause, I mean, and get it to conference that way. I'm
Okay.
happy to do that too.
Mr. Chair,
What,
I
Boys
had
Go?
an idea
What's your idea,
of
Boys Go?
Nazi symbol commonly known as swastika.
Okay, so on line 14, we had causally placed A, insert Nazi symbol commonly known as, and then deal with this later.
We can
Okay?
wordsmith it later.
Boysko moves and Deeds seconds that amendment. All those in favor say aye. Aye. Anybody opposed?
Move the report and re-refer to
Okay.
finances.
Okay, is there anybody opposed to the bill? I hope
Mr.
not.
Chair,
Yeah, what? Jordan?
I appreciate Delegate Simon's intent here, but I'm still not really comfortable with this. I think we haven't heard from the Hindu community at all until I started hearing from them yesterday and this morning. And, is there a way that we can send this to finance without recommendation until we get to hear from some more of our constituents?
No. We need to make an amendment so we force Simon to go into conference. Or else he could just, or the bill could just get back and he could just accept it as he likes it, and we'd never see it again with no amendment to deal with the concerns we have. That's why we need to make an amendment.
So the amendment says
Nazi symbol commonly known as.
everywhere that says swastika, we're adding that.
Yeah.
And Mr. Chair, for what it's worth, the emails that I've gotten have asked for a similar, not maybe these specific ones, but a similar amendment. So I think that an amendment would satisfy the folks that you've heard
Okay,
from
so
your email.
it's been moved and seconded that we report and refer the bill to finance as amended. Clerk, open the roll. Okay.
It's 15, no zero.
Okay, bill reports goes to finance. Simon, you got some
Thank you.
work to do. Perry might have some ideas for you, it sounds like.
Thank you.
Okay, I got Delaney, Thomas, Reeser has a little one. I think Delaney's probably needs the most discussion. Thomas, I'm assuming we're just gonna conform. Link, we gotta do Reeser, he has to get to finance, get up here. Delegate Reeser had a bill that's is it Boyd Graves?
No, Virginia Bar
Okay,
Association.
Virginia
real
Bar
estate section.
Association bill, and she is sick, can't be here, needs to go to finance. Well, wait a minute.
I couldn't figure out what this is all.
Yeah, what's this all about, Link?
What is it?
1913.
Mr. Chairman, I have somebody online who's ready to explain it to the committee quickly.
I think this is good.
Okay, online person, identify yourself and speak.
Sean Lundy, you may now speak.
Be quick, be quick. Yep.
Next, Paul Lundy, the purpose of the bill is to simply
make consistent the way that commercial deeds of trust are assessed fees across the state.
This is.
Okay, but I get you want people to be consistent, but I guess what the issue is, there's some clerks in some part of the state that are requiring recording fees, when in other parts of the state, they're not requiring recording fees on situations with deeds where there's no consideration transferred as part of the transaction. Is that right?
Right. So oftentimes in a commercial deed of trust, the deed of trust will say not just deed of trust, it'll say financing statement, assignment of rents, and some other instruments. I could take that instrument into one courthouse and the clerk would charge the fee for a deed of trust. I could take it in another courthouse and the clerk would charge the fee for a financing statement, assignment of rents, deed of trust, UCC filing security agreement, etc. So it's simply to make it consistent between across the state as to how the clerks address that issue. And then there's also a quick link deed issue.
Okay, are the clerks here? There's no clerks association here? Carlos, why are your clerks causing all this consternation for us?
We never cause consternation, Mr. Chairman. With respect to the bill, and I don't know if you have, we've discussed this with.
I'm sorry, but before
I'm
you
sorry.
speak.
Yep.
There's a substitute before us. It's been moved and seconded. We adopt the substitute. All those in favor say aye. Aye. Anybody opposed? No. Okay. Now we're talking about the substitute.
With regard to the substitute, Mr. Chairman, we've had a chance to speak to Mr. Link, and we appreciate working with him and with the patron and with Mr. Lundy with the VBA. We're not opposed to substitute. I believe there was a change of, or an additional word. to
Okay.
add the word
Sounds like we
single.
got peace in the valley. Okay. Been moved and seconded. We report the bill referred to finance. Clerk, open the roll. Okay.
Ayes 14, no zero.
Deeds wants to talk about indexing fees on the floor. So, next up, Thomas, I'm going to call you next. This is a different approach to the fentanyl, fentanyl homicide problem. You've chosen to, instead of the approach we took, go with involuntary manslaughter with some tweaks. My thought was we were probably just going to conform this to ours, and this will go to conference and we'll chat. But anything you want to say?
No, Mr. Chairman, you described it pretty succinctly.
Okay, anybody have any questions for Thomas? This is a very different approach than what we had come up with. That's what we do by conforming it. To mine, or McDougal's. No questions, yeah.
Mr. Chairman.
McDougal.
So Doug, Thomas's bill doesn't limit this to minors.
Correct.
Correct? So you can be 18 years old and still be able to prosecute the person if your 18-year-old dies, not just your 17-year-old.
Right.
And it also says that the substance is a proximate cause of the death. It doesn't have to be does it have to be the sole?
Nope, no.
And does not have to be the sole, which are two of the concerns that I have about the language that you came up with. Because most of the fentanyl that's being sold is not being sold as straight fentanyl. It's fentanyl with something else.
Right.
It's fentanyl with heroin, it's fentanyl with oxy, it's fentanyl with marijuana. And as a result, it makes it almost a legal impossibility to have a medical professional say that it is the sole reason. It might be the reason, but if you have multiple other drugs, that's difficult. So
Right.
I like this.
He also has the accommodation defense, but he does not have the pile-on language that we had that says you can't charge him with all the other things, like the weapon of terror, distribution, transportation, all that stuff.
Add the pile-on language to this and take this approach.
Deeds.
Chair, I move that we conform this to the bill that passed the Senate.
Okay, it's been moved and seconded. We conform the bill. All those in favor of conforming, say aye. Aye. Anybody opposed?
No.
Okay.
Usual suspect.
Okay, I'm going to say the ayes have it unless anybody wants to record a vote.
6 noes.
Okay. Doesn't look like.
Report and re-refer as amended.
It's been moved and seconded. Report the bill re-referred to finance. Clerk will open the roll. All right, bill reports refers to finance. Thomas, that's your only one, right?
Yes, Mr. Chairman.
Okay, Delaney, you've been there a long time. All right, and you have a bill that we've seen before.
Yes, Mr. Chair. I
And
will
give
try
us
to,
sub this time or anything, or no?
not for the Senate. I think we worked everything out coming out of the House. The version
Okay.
before you is our version. So I'll try to run through it as quickly as I can what this bill does. I know several of you have heard this bill or some similar to this before. So under current Virginia law, prosecution can ask to petition the judge to allow a minor child to testify remotely via CCTV, or in this case, maybe other similar technology, but for the sake of conversational, continue to call it CCTV. They would have the ability to petition to ask the judge for this provision if certain standards are met. They have to be able to have a persistent refusal to testify despite judicial requests. They have to have let me check the substantial likelihood or a substantial inability to communicate the offense, or under current law, they have to meet a standard of severe emotional trauma. We know a lot more about trauma's impact, both on children, on children's brains, and on the quality of testimony that's received when a child endures what case law would decide is severe emotional trauma. We're talking kids who are threatening suicide, kids who are having severe emotional breakdowns, lasting, impactful trauma on this child's life. We are simply trying to reduce the standard to a moderate level of trauma. This does not require that the court provide this option. This simply allows the prosecution to request that the judge consider, based on expert testimony, that a child will suffer from moderate emotional trauma, that the judge would have the ability to consider and determine whether remote testimony, which still allows for cross-examination, could be conducted in that particular hearing. And that's what the bill does.
Are there questions for the patron? The moderate on line 33, that's going to be up to a judge to decide that?
Mr. Chair, it is an expert testimony that would need to be provided that the child will present with at least moderate emotional trauma as a result of testifying in the presence, and the defendant's presence, and not just the courtroom in general. So there's also the added requirement that an expert would have to testify, and it's not just about trauma of being in a courtroom, it's a trauma of testifying in front of the defendant.
Okay, we're going to go 3 and 3 for people that are, if you're for the bill, come on up. 3 minutes.
Online in support, please raise your hand and put your camera on.
3 minutes.
Mr. Chairman.
Senator McDougal.
I like a lot of this. The question I have is about, is it written so it has to be audio and video? It's not just audio.
That's right, Mr. Chair. It is closed-circuit TV, so this would be a video with audio. They would be able to cross-examine. It would just be removing the child from the courtroom environment, but would still have audio and video components.
I don't like it either. Please go ahead. Okay, I've asked for people
All right.
to come up.
Go ahead.
Thank you, Mr. Chairman. Kate Hanger, Virginia Victim Assistance Network. We support this bill. Anything that can be done to mitigate the further harm of children who have been sexually abused and raped, we're in support of. Thank you.
Sunu Jane Cooper with the Virginia Sexual Domestic Violence Action Alliance, and we are in full support of this bill. Any opportunity for a child to not have to face their accuser or speak to violence that they've witnessed in the home, and that is the most trauma-informed process we support. Thank you.
Okay, online.
Patrick McKenna, you may now speak.
Patrick McKenna. Thank you, Mr. Chairman, for the opportunity to speak. Patrick McKenna, Virginia Coalition Against Human Trafficking. We highly support this bill, having worked with survivors, adult survivors, over the last 12 years who experienced extreme panic and such, even facing their accuser. To subject a child to that multiplies the fear factor and the inability to actually testify and actually obtain justice for that child. So we ask the committee to support the bill. Thank you.
Okay, I think that's it. Let's reset the timer.
Mr. Chair, Rob Hogan-Class for Justice for Virginia. Courts have made clear that the single most important tool a defendant has for testing the reliability and testimony and truthfulness of a witness is cross-examination and face-to-face confrontation by one's accuser. The most difficult type of unreliable evidence to expose is indeed false witness testimony. CCTV testimony by definition infringes on the right to confrontation and thereby increases the likelihood of a false conviction. 71% of false convictions were based at least in part on unreliable witness testimony, a disproportionate number of which was testimony by children. For this reason, exceptions to the Sixth Amendment right to confrontation must be narrow and limited. That's not just our opinion, it's what the Supreme Court of the United States said in Maryland versus Craig, a 1990 case which is still the benchmark for whether CCTV testimony is admissible. That opinion and the many states that have codified it in statutes since then allow such testimony if a child will be traumatized by testifying in the defendant's presence, but only if the trauma impairs their ability to testify or their ability to testify reliably. Just pointing out that a child will be traumatized is almost never enough unless that trauma is severe. Unfortunately, the current draft of this bill allows exactly what Maryland versus Craig, in Justice O'Connor's opinion, and the vast majority of other states do not allow CCTV testimony on a mere showing of the possibility of moderate trauma generally, even if it has no impact whatsoever on the child's ability to testify reliably. We believe that very, very permissive definition to violate the Sixth Amendment, right to confrontation, and even more importantly, we fear that such a permissive application of this practice will lead to false testimony and false convictions. We're frankly worried about cases being reversed on appeal and having to be retried, which would then force the child to come back to court. We oppose the bill.
Okay, that's it for opponents. Anybody opposed online? Nobody online.
So, Mr. Chair, if I
Yeah.
can respond, I think there's two different lenses by which I'd like the committee to consider this. One is what is current law, which already allows the court to have this petition. This is not introducing a new petition. This is simply amending the standard of what is currently allowed by law. The court will still have the opportunity to deny that petition. The Maryland v. Craig case that is often cited in this states the language of more than de minimis. Moderate is more than de minimis. And so we are taking our courtroom with this bill into a more trauma-informed era, which I think is based on all the science that we have learned since this code section was written. And so, I think we can see it through the lens of what is best for children, what is most trauma-informed for children. But the second thing that I'd like the committee to consider is the question around the quality of the testimony. And I think that it's important to understand the psychology of trauma. And the most accurate ability to recall details, memory, those are severely altered when trauma is present. So allowing remote testimony where cross-examination is still available would actually enable the defense to gain a more accurate testimony through cross-examination while also preventing children to have to go through that re-traumatization.
Okay, thank you, Delegate. I think council has some suggested language. I know there's some concern, at least some of us, I'm not sure exactly where the votes are on this, about lowering the threshold to moderate, whether that's constitutional or not. Council, you have a suggestion?
Yes, sir. Mr. Chairman, on line 33, and the patron is correct about her reading of Craig versus Maryland, but to make certain of that, I would incorporate the Supreme Court's language after the word trauma. I would suggest adding that is more than nervousness or excitement or some reluctance to testify. And then on line 34, after the word generally, I would add, and where such trauma would impair the child's ability to communicate. Both phrases come from the decision.
Move the amendment. Second.
Okay, any discussion about that? No discussion about the amendment. Stuart, you have discussion.
I got a question about why wouldn't we leave that up to the expert? Then,
what does that mean?
Well, I mean, the language that we're putting in would define what it is, and it seems to me that the expert, because you got to have expert testimony to get this, is in a better position than we are
It's not
to determine what the moderate trauma is.
Right, but this says only certain kinds of trauma count and not just general trauma.
Mr. Chairman, I understand what it says. My question is, why would we define moderate trauma for the expert when the expert is the one testifying, and we're telling the court that we must have expert testimony, but then we're telling the expert what he has to find. I think we should leave that within the parameters of the expert, is my point.
Okay, Carol Foy, is that who I heard?
Yeah, Mr. Chairman, just briefly, I think you have the language in there to ensure, I mean, just testifying in open court with the accused there can be traumatizing in and of itself, but we want to make sure that it's not just a type of trauma that's, attributed to just testifying, like anxiousness and nervousness, or excitability, that it needs to rise to a certain level because you are literally infringing on someone's Sixth Amendment constitutional rights in this situation. So you want the expert witness to be able to say this is a higher level than what everyone experienced when they have to testify in open court against an accused. And that I think that there needs to be a nexus that nervousness, that heightened sense of, because we're lowering the standard. We're literally taking it from severe trauma to moderate. Almost every person who testifies has some type of trauma, and you can categorize it as moderate. So I think we don't want to open the net too much, because then you'll have pretty much every child testifying by CCTV, and this really should be for exceptional circumstances where there's a nexus between the type of trauma that child will have and the case that they're testifying in, and that it's not something that's normal, that it is a heightened level which would necessitate the CCTV in the first place.
Perry, do you have something on this? You were in the queue, I saw.
I do. I'd like to hear from Delegate Delaney on this. What my position on it is that the statute says at least moderate emotional trauma. So it's not any trauma. I agree with the members of the dais who have said, like, hey, testifying in court is stressful for virtually everyone, and more certainly for the people whom this bill is most definitely for the people in this bill, which are the youngest of the young and the most severe and excruciating circumstances that we find ourselves in and that are prosecuted in the Commonwealth of Virginia. Horrific rape cases, parents that are murdered in front of very small children. You're talking about 5-year-old little kids who walk into the courtroom and go sit up on pillows at the front of the courtroom just so they can be seen. So,
Delaney, you got feedback? Or go ahead.
So, Mr. Chair.
I thought you were done. Go ahead. You paused.
You say I speak too fast, slow down,
Okay.
I slow down, we think you're done.
Okay.
Lose-lose situation. What I would say is I think that at least moderate emotional trauma helps protect against some of what is being talked about here. Nervousness, I don't think would be categorized by any sort of expert in child psychology as being moderate emotional trauma for what that's worth. And I'm not inherently opposed to Mr. Benjamin's edits because he is, I think, adding in what is part of the language on this. But I'll be honest, I just don't know that it's necessary. But I'm happy to hear from Delegate Delaney.
Thank you, Mr. Chair. I mean, I would say, look, I would like to see this bill become law, and I recognize being kind of at the will of the committee with where the committee sees this bill needing to go with the language. I would answer the senator's question, however, with current law does not require the expert testimony. We added that as an attempt to make a compromise with those who oppose the legislation in order to reduce the standard to moderate. Current law would just be substantial likelihood. And so we are adding an expert now that needs to be required to testify that a child will suffer at least moderate emotional trauma. And I think to the senator's point, to an expert, moderate emotional trauma has a definition. It's not just being nervous. It's not just, not wanting to be in the courtroom. It's not just even not wanting to be in front of the accused or facing the accused. I think that, at least moderate emotional trauma is going to have a meaning to that expert who we're now requiring to testify that would demonstrate that this is going to have a lasting impact on this child's development because of the requirement that they would have to face their defendant face-to-face.
Any further discussion about the motion to add this language? Favola, is your comment on the motion to add this language?
I have a general comment.
But not on this, the motion. We haven't done the amendment yet.
I am going to vote for the amendment if you're calling for a vote.
No, I'm trying to figure out, you're in the queue to speak. I want to make sure you want to speak on the amendment.
No, I want to speak on the general.
Okay. Anybody else have any further feedback on the amendment? Okay, all those in favor of the amendment, say aye.
Aye.
Anybody opposed? No. I think the ayes have it, although a lot of people didn't vote.
I just have,
Okay, the bill's amended. And we've already heard it. Favoli, you're next.
okay, thank you. Thank you, Mr. Chairman. I mean, there is some value in moving towards a trauma-informed environment, especially if we're looking for justice. Enabling a child to be able to testify, I mean, certainly through a two-way audio or video, it definitely adds some information to the case. And as I read the bill, on line 32, it says it's the court's finding by clear and convincing evidence. And that's a pretty high bar, that the child will suffer at least moderate emotional trauma. So there are guardrails in here. I do understand from the attorneys that we have to balance the constitutional rights of the individual being accused, but with, I believe, the constitutional right of a child to be able to explain or express what actually happened. I think this bill is worth a try, and at the right time, I'm going to move that we report the bill and we refer it to finance.
Okay, McDougall, thoughts? No?
Mr. Chairman, I like the bill. I do have a little question about the 30-day notice, the 7 days now, maybe it needing to be a little bit longer, but there are some times when you don't have that much notice, particularly if a juvenile is being held. You don't have 30 days. So I'd like the notice to be a little bit less. Current law 7, the bill says 30. I think 14 is a good number in between. So I'd move 30 be 14.
It's been moved and seconded. We amend the bill to 14. Any discussion about 14? Okay, all those in favor say aye. Aye. All opposed?
Move
One no.
Mr. Chairman, I move that we report the bill as amended and refer it to finance.
I was in the queue.
I don't have anybody else in the queue on my screen. Okay, you want to say something?
Okay, very briefly. Speaking to the bill, I know that there is concern, and I appreciate the patron for bringing it. I know why she bought it. I am going to support the bill because of the language that was added from the case. But I just also want to be mindful that it isn't easy for people, and especially children, to testify against someone. And we do want to make evidence and trauma-based decisions, but it's also not easy to sit behind bars for years for a crime that you didn't commit. And in fact, in Virginia, 3 of the most recent exonerations were defendants convicted of sex offenses due to false child testimony. So where the children later actually recanted. And so I want to be careful that if we're chipping away at an accused Sixth Amendment constitutional rights to confront witnesses against them, that we're very mindful of this. And so we have to balance the trauma experienced by a child, but also the fact that this is one of the safeguards to prevent people having false convictions and cases from being overturned and retried. So I want to thank the patron for bringing this, and thank you for being open and willing to the amendments, and I'll be supporting.
All right, any further discussion?
Mr. Chairman, can I just speak to the bill
Barry?
briefly? Thank you, Mr. Chairman. I just want to thank the patron for bringing the bill. It's not uncommon when you prosecute domestic violence or child sex crimes, like exactly what this bill protects. It doesn't protect all crimes, not all kids in all cases, but very specific types of crimes that include domestic violence and sexual assault, kidnappings. When you have very small children, right, there are protections in the case law for small children, right? You have to be competent to testify. The judge has to make a determination that a child is competent. That's not an easy burden. We used to give competency tests to kids to see if they could come in and testify, right? What are the questions? They're laid out in the judicial manual. But you have to be able to know that they understand the difference between a lie and a truth and what the difference is, and that when they're put under oath that they have to testify and tell the truth, not guessing at things. And it is very difficult, very difficult. I think the youngest child I ever had testify was about 7 years old.
I'm sorry.
And so I just want to thank the patron. I think this helps protect the youngest of the young in the cases where we have very small children who are victims of rape and other of the most horrific crimes, who are then required, which many adults can't do for what it's worth, to walk into a courtroom, walk down the center aisle, and go stand and sit in front of the very person who did the most horrific acts to them that will ever probably happen in their entire life. And it's certainly a balancing. Sixth Amendment right to confrontation is a very important right. But the courts have upheld this exact type of thing to make sure that we're reaching the right balance and making sure that these cases are prosecuted, that they're prosecuted appropriately. We've done a number of other things to address that children are treated the way that in trauma-informed environments, including child advocacy centers, making sure that people are trained in forensic interviewing children, that we're not making suggestive comments or questions to them. And I think this is further down the road of making sure our system is fair and just to all the people in it. Thank you.
Okay, any other discussion? Okay, it's been moved and seconded to report the bill refer to finance. Clerk will open the roll. Don't get up yet.
Ayes 12, noes 3.
Okay.
Mr.
Bill
Chairman.
reports refers to finance. McDougall, you have a motion.
Mr. Chairman, voting on the prevailing side by which HB 2724 failed to report, move that that vote be reconsidered.
Okay. Clerk will open the roll. Motion reconsider.
We.
No, we're gonna go by for the day.
Ayes 15, no 0.
Okay, that bill will now go by for the day. Thank you for all your work today. 52 bills done. Excellent work. Probably the most we've ever done since I've been chair. Thank you. We're adjourned. God, thanks.
This is the Senate of Virginia, Richmond, Virginia. Senate Committee Room, A305. Did you know that you can watch the Senate live on YouTube? Visit the channel by browsing to youtube.com/@Senate of Virginia. That's youtube.com/@Senate of Virginia. Senate Committee Room, A305. This is the Senate of Virginia, Richmond, Virginia. This is the Senate of Virginia, Richmond, Virginia. Senate Committee Room, A305. Did you know that you can watch the Senate live on YouTube? Visit the channel by browsing to youtube.com/@Senate of Virginia. That's youtube.com/@Senate of Virginia.